It's unusual to have these out of session meetings, and I'll explain more about that. But first, I wanted to ask Senator Payne to open us in prayer like we traditionally do, and then I'll have the committee members introduce themselves. Senator Payne.
Thank you, Madam Chairman. If y'all will bow with me. Dear Heavenly Father, we come to you today, Lord, and we just thank you for all the opportunities you bring to us each and every day. We thank you for the breath of life that gives us way to that opportunity. Lord, we just ask you to lead us and guide us in all our endeavors in this committee. Lord, lead us to make it better. Lead us to find a way for those who are struggling across our state. And Lord, the most vulnerable among us are those kids in foster care. Lord, just be in our hearts and our minds and lead us in the way you would have us to go so that we can best direct those and those young lives throughout the state of Georgia. Thank you, Lord. And we just pray all this in Jesus' name. Amen.
Thank you, Senator. Okay, I'm Senator Kay Kirkpatrick. I represent District 32, which includes parts of Cobb and Cherokee counties. And I'd like for my committee members to introduce themselves. There are a couple who could not be with us, and there may be one person coming in late, but this is actually a great turnout for a summer meeting. So thanks to all of you all for coming. Senator Burns.
Good morning. I'm Max Burns. I represent Senate District 23, which is East Central Georgia, Augusta, Richmond County, south halfway to Savannah, and I have the privilege of chairing higher education. It's great to be on this committee. It's a very meaningful committee.
Thank you. And my vice chair, Senator Hatchett.
Bo Hatchett. I represent Senate District 50, which is 9 counties in Northeast Georgia. Glad to be here, and really, it's been an honor serving on this committee.
Thank you. Senator Mallow.
Thank you, Madam Chair. I am Senator Derek Mallow. I represent coastal Georgia, most notably known for a 2-lane road called I-16. And I happen to be the self-proclaimed king of that road. So excited to be here with you.
Thank you. Senator Jackson.
Thank you, Madam Chair. I'm Senator Kim Jackson. I'm really honored to be here. I represent District 41, which is a portion of DeKalb County on the east side, and always grateful for the work that we're able to do together.
Thank you. Senator Estevez.
Good morning, everyone. Jason Estevez, the proud state senator from Senate District 35, which includes parts of Cobb and Fulton County. Happy to be here and talk about this important work.
Thank you very much. And I want to thank my administrative assistant, Hannah Holcomb, for helping us put this together, and all of the people that work to help the meetings go smoothly, Senate Press in particular. They've gone out of their way for this meeting. This special committee meeting regarding the Interstate Compact for Placement of Children came about because of concerns raised during the legislative session about the ICPC process in Georgia. We did not have time during the regular session for a thorough discussion in our committee, so here we are. We'll not be voting today or making any motions. The purpose is to understand the process and to give all parties a chance to be heard. This is being live streamed and will be available for viewing later, and any material that's been handed out to the committee will be emailed to the other committee members after the meeting. The run of show is that we're going to have a national expert on the national ICPC process on Zoom, followed by our state ICPC folks explaining how this is working in Georgia. We'll have testimony after that from people who had requested to speak, including adoption lawyers and child placement agencies, and a brief presentation on the Uniform Unregulated Child Custody Transfer Act. And then we've got a few people who have signed up to testify. The speakers have been given their time parameters, and the committee will be able to ask questions of each of them. The sign-up sheet we have up here, and depending on the number of how long everything takes, we may need to put some time limits in place near the end. I'm trying to wrap this up by noon if possible. Like all our meetings, we're expecting everybody to be respectful and to keep in mind that they need to be concise when speaking. So thank you very much for attending this meeting about an important topic, and let's get started. I'd first like to introduce Rick Masters, and committee members, you have him in your folder. You have his CV handy. Mr. Masters is General Counsel to the Interstate Commission for Juveniles, providing legal guidance regarding the compact and its administrative rules, including application and enforcement, to the member state commissioners of the ICJ and other state officials. He's a recognized subject matter expert in the field of interstate compacts and provides legal advice to several other compact governing boards and agencies, including the Interstate Commission for Adult Offender Supervision, the Interstate Medical Licensure Compact Commission, the Interstate Commission of Nurse Licensure Compact Administrators, and the Association of Administrators of the Interstate Compact for the Placement of Children. He frequently testifies before state legislative committees concerning a wide variety of compact legislation and has also provided testimony to the U.S. Congress. So we're very fortunate to have him to give us the lay of the land. Mr. Masters, can you hear us?
Yes, I can, Senator. Thank you for the opportunity to be here today.
Thank you. We've got you loud and clear. Please go ahead.
All right. Well, I appreciate the opportunity to give you an overview of this important compact. I worked for over 25 years with the National Center for Interstate Compacts, which is affiliated with the Council of State Governments, which many of you may know as the Southern Legislative Conference, which is the southern region of CSG. I helped found the National Center for Interstate Compacts, and during my tenure there was honored to be called upon, along with several co-authors, to provide a legal treatise, which is in my hands today, on interstate compact law, which is the only volume of its kind. And our sales from the American Bar Association, I'm told, have exceeded that of the Amish phone directory. So you can tell how many people are buying the book. I'm being facetious, but it is an important area of law, and I've been involved in this situation and with this subject matter, as the senator stated, for many years. The ICPC is one of a minority of compacts to which all 50 states are members. There are less than 24 of these types of compacts where all states are members, but as you know, as members of the legislature, a compact is something that is not unusual for legislatures to consider or for states to join. And on average, every state is a member and has enacted approximately 25 compacts or more. Georgia is actually in the or more category, and we're glad for that, because as I know you are familiar, interstate compacts are not just statutes, they're contracts among the states which allow them to be enforced in a uniform way. And it's a way that the Constitution of the United States has provided for states to exercise their sovereignty collectively, so that we don't need the federal government to step in and legislate for us and usually send us the bill when that happens, as you know. And the ICPC is one of those compacts which was first enacted back in the 1950s. Georgia was a member of the first compact, and it's important to understand that that compact that was enacted in 1950 is in the process of being replaced, because we have drafted a new compact since in the 1950s. Administrative law certainly was not what it is today, and there have been many changes in the way states have arranged their child welfare offices, and many of the rules of the compact, the original ICPC, have been subject to some court challenges, and there have been a number of court decisions that have made it difficult, if not impossible, to enforce the regulations that have been enacted over the years, simply because of these conflicting court decisions. So the new compact has adopted a new rulemaking procedure, which adds clarity to the process and hopefully will allow us to avoid some of the judicial intervention, which has made it more difficult to enforce. It has specific provisions for adoption of the rulemaking process, and it provides a more enhanced governing structure to allow the states to enforce this agreement among themselves so that it can be carried out in the way that it should be. And most of the problems that have developed are due to the need for updating this compact. I'm pleased that Georgia has enacted the new compact. Since there are all 50 states that have joined the previous compact, it was determined that in order to replace it, we needed to have 35 states to have enacted the new compact for it to take effect. Unfortunately, but with the hopeful attitude that this will be completed as soon as possible, we have 19 states as of earlier this week when the legislature of Nevada enacted the new compact as well. So we still have 16 to go before this new one becomes effective. But I'm confident that that is on its way, and that will hopefully help us with some of these issues that have brought you here to this hearing today. And certainly, there's no perfect legislation, but we feel the new legislation will solve many of these problems. But I'm going to take you through very quickly the way this process works under the current ICPC, and the process has remained essentially the same, and the goals of the compact are the same, but the way we carry it out has been updated and enhanced, and hopefully will be helpful to these problems. If the presentation is on, I'm not sure how to advance the slides, but maybe I can get some help from our technical folks to do that. And I do have a slide presentation that is available. If I
Can you share your screen, Mr. Masters?
Let's see. I hope so.
So I can't.
Okay, let's see. I think. Okay, I've got the screen sharing in place. Now, I'm not sure about the. I know I sent the slide presentation earlier, so I don't know if that is keyed up so that we can view it.
Give us just a minute.
Okay.
Meanwhile, any questions from the committee on what Mr. Masters has said so far? I don't think do we have that?
I do have a question.
We don't have. Okay. Senator Hatchett.
Are any of our neighboring states ones that have not joined the revised interstate compact yet?
I'm geographically, I don't know if I can touch all of the border states that are involved, but I do know that some of your border states have enacted. I don't know if all have done so, but I could provide you with a list of those offline since I don't have the complete list in front of me.
Okay. Anybody else? Okay, stand by. We're trying to find another way to get the presentation up.
Okay.
Okay, your presentation's up now.
Okay. I'm trying to, here we go. As I indicated, this was drafted back in the 1950s. The first state to enact the compact was the state of New York. And as I've also explained, and I know you understand, this is not a uniform law. It's actually a compact, which means it is enforceable among the states. And the provisions of the compact are uniform, and the regulations are supposed to be followed as well. Next slide, please. The primary goals of the compact have not changed. The purpose of the Interstate Compact for the Placement of Children is to provide protection for those children that are placed across state lines, primarily those who are adopted and those who are placed based on their status as wards of the state and are transferred for both medical reasons and because of placement needs of these children. The compact also provides for a basis to determine the appropriate legal and financial responsibilities in the interstate placements pursuant to each state's laws. Next slide. The placements that are covered, as I said, primarily we're talking about adoptions and placements into foster care. But among that group of children, that includes placements into residential treatment facilities, placements with parents and relatives when a current parent or guardian is not making the placement, and placements of adjudicated delinquents into institutions for their care. Next slide. The states are divided into sending agencies or sending states and receiving states, and the statute classifies what each group of states is required to do under the compact, depending on whether they're a sending state or a receiving state. As the slide indicates, the sending agency has the opportunity and the responsibility of obtaining home studies and to make an evaluation of the proposed placement to make sure it is safe and effective. The receiving state, which is going to take custody of the child, has an opportunity to ensure that the placement is not contrary to the interest of the child and can block that placement if it turns out that the court decides that it is not in the best interest of the child. Applicable laws and policies of the receiving state are enforceable under the compact to make sure the state has followed these. And the sending state's court continues to have jurisdiction over the placement once the child moves to the receiving state in case need arises for further action. The sending state is also able to obtain supervision and regular reports of the child placement to make sure everything is going according to plan. Next slide. The sending state is responsible under the compact, and this has essentially remained the same under the new compact, is to prepare referral packets to forward to the ICPC office in the receiving state. And again, as stated, the sending state retains jurisdiction to make sure this process proceeds as it is supposed to. It is also responsible, the sending state is also responsible for ongoing planning and for maintaining financial obligations as well as travel arrangements for these children. Next slide. The receiving state is responsible to review and forward. Under the compact, the receiving state is to receive referrals from the local agency to ensure compliance with the sending state laws, to authorize the placement can be made by the sending state and that it doesn't violate the compact or the compact rules, to monitor placement status, to resolve problems with the other state and the receiving state local agency, and to ensure ongoing compliance with other state laws. Next slide, please. The receiving agency is responsible also to complete the home study and make recommendations regarding the placement, to complete reporting requirements under the compact, to ensure that requested services required under state law are received, and to notify the ICPC office when problems occur, and recommend dismissal of a case or closure of a case if necessary or appropriate. Next slide, please. The frequently reported problems, and I'm not sure, but I'm sure we'll hear today how many of these, if any, are part of the issues that have caused the need for this hearing. The leading causes of the delay encountered in the receiving state are incomplete or missing information from the packet, missing court orders, insufficient information to address the child's needs, and absence of appropriate signatures that might have been required for the forms that are used to effect these transfers. There are situations which occur when the sending state office is bypassed, which is not supposed to happen, but that is a frequently encountered problem. Next slide. The information provided includes the child's social history, including medical condition, education and emotional needs. There needs to be the appropriate court order to verify jurisdiction, a child permanency plan, a plan for meeting the costs of care in the receiving state. If there's an Indian child welfare issue involving a Native American child, that has to be provided if appropriate in those cases. And a home study of the proposed placement is supposed to be included if completed. Next slide. Essentially, that is the process, and both receiving and sending states have responsibilities that are supposed to be followed. Certainly, as they say, many a slip between the cup and the lip. Sometimes things don't go as planned, and I know that's one of the reasons that we're here today. But if there are questions, I'll be happy to try to field those, and I appreciate the opportunity for us to discuss these issues today.
Thank you, Mr. Masters. I do have one question. Having carried some compact legislation previously, I know that the language in the law is consistent across the states.
Right.
How much flexibility do states have in how they administer the compact, and where does that come into play?
Well, the compact, like other compact statutes, as you just stated, Senator, it is contractual, and so that's what interferes with the ability to amend it. You know, most legislation can be amended, and I know that's what you folks spend a lot of time doing. But a compact simply can't be amended if it substantially changes the obligations that are part of the compact statute. So you can make some changes to a compact, but they have to be for the purpose of enhancing or improving the way in which the compact is applied, as opposed to any significant change in the language of the compact itself. But it is broadly drafted so that the rulemaking that the compact is authorized to engage in is really the place where many of these problems are confronted and resolved. So I think that under the new compact, you've got the authority under that compact to make some changes, and those will primarily be through rule changes, and certainly the legislature can supervise that process and contribute to it if needed. And as long, again, if there are changes made to the compact itself, statutorily, that has to be consistent with what the other states have enacted. To my knowledge, Georgia has enacted the version of the compact that has been adopted by the other 18 states that have also done so.
That's very helpful. Thank you. So in terms of uh, what's better about the new compact, it sounds like from what you're saying that the new language was intended to address questions that were too vague or were not clear in the original law. Is that accurate?
Yes, the changes were primarily to the governing structure. The old compact simply didn't include much in the way of institutional governance by the compact commission that is appointed, where members of each state manage this compact through a governing body called the Association of Administrators of the ICPC. And that group still exists, but the manner in which they are required to function is much more detailed, and the types of revisions that you would expect any administrative agency in the 21st century to have been considered primarily in the area of rulemaking. The compact has very little to say about the way in which rules are made. The new compact adopts the principles that you would expect in the Model State Administrative Procedures Act, which I know Georgia and most states have used as a basis for your administrative rulemaking. And so this updates that process so it's done in a way that you can have more confidence in the process. And that was the primary motivation for the changes to the new compact.
Thank you. Any other committee members have a question for Mr. Masters? We appreciate you being with us, and I know that you can hang on for a little bit, but that you have another commitment. So we appreciate and we'll stay in touch with you.
Thank you so much, and I'll be happy to answer questions offline and be available to your committee for any additional information or assistance that we can provide.
Thank you so much.
Yes.
Okay, next we're going to hear from our state folks. And I think first in the lineup is Mr. Brian Pedersen, Deputy Commissioner for Health Law and Policy for DHS. Okay, the floor is yours.
How much time do you have allotted for us? I just want to make sure I keep
Well,
everything.
you guys are sharing your time, so I'm hoping that you can manage in about 20 minutes.
We can do that. All right. Thank you, Chairwoman Kilpatrick, committee members, for the opportunity to speak and present to you today. My name is Brian Pedersen. I am Deputy Commissioner at Georgia Department of Human Services, and I oversee our Office of Health Law and Policy, which I will refer to from time to time as OHLP during this presentation. To start, let me just share a little bit about myself and my background in this work. I have been a licensed attorney in the state of Georgia for 23 years. I've been a state employee for over 6 years, and I've been serving under the strong leadership of Commissioner Brose since May 1st of 2022. Prior to my state employment, I was practicing attorney primarily in family law, and I personally handled adoptions, including DFACS adoptions and interstate adoptions. I've also served as the juvenile prosecutor in Coweta County and as an assistant district attorney specially appointed to the juvenile court in the Fayette Judicial Circuit. The Office of Health Law and Policy, OHLP, is a unique office at DHS. In that outside of our core duties, our office seeks to identify areas throughout our various agent offices and divisions where we can improve processes to enhance DHS's delivery of services to the vulnerable populations that we serve. OHLP was the brainchild of Commissioner Brose and our late Chief of Staff, Craig Foster, and I've been grateful for their support that they have showed in me and the members of my office since the beginning of our work at DHS. Craig unofficially named our office Skunk Works, and much like the Lockheed namesake, he expected OHLP to be a driver of innovation and improvement across the agency. Commissioner Bros moved the DHS ICPC unit team under OHLP in February of 2025. Since this time, our office has been examining all of the policies and processes of the ICPC unit, as well as discussing operations and potential challenges within the DFACS regions. I'm fully confident that each of you, along with our state leaders, private adoption attorneys, placement agencies, and the citizens of the state of Georgia, will see a transformational change in the overall operations of the ICPC unit, including the timeframe at which the state of Georgia processes all ICPC regulated adoptions from start to finish. We have already updated the ICPC website to be even more robust, include more information, forms, and a streamlined checklist for Regulation 12 adoptions, which are private agency adoptions. That's only the start of the work that we have to get done. So all I can say to you right now is that we're just getting started on this. I do have a few slides to go through, but before we do that, I do want to introduce you briefly to my fellow ICPC staff members and partners here with us today. To my immediate right is the compact administrator and executive manager of the ICPC unit, Mr. Aletta DeJola Adigan. Mr. Adigan has been licensed to practice law in the state of Georgia since 2015 and a state employee since 2017. During his part of the presentation, Mr. Adigan will speak with you all concerning ICPC procedure, timelines in the state of Georgia. Additionally, on my far right, you'll be hearing from Ms. Dina Krim. Ms. Krim has been licensed to practice law in the state of Georgia since 2006. She has been a special assistant attorney general since 2006 and assigned to juvenile and DFACS cases. At the request of Commissioner Bros, Ms. Krim was brought into DHS to review private adoption ICPC cases in September of 2024 to provide legal expertise of these matters. As such, during her presentation time, Ms. Krim will speak with you regarding the procedure and timeline of Regulation 12 private adoption. Mr. Masters covered a lot of this, and I do want to save time for all your questions, so I won't belabor you on everything. But as he explained, the ICPC is an agreement enacted by all 50 states, District of Columbia, and the U.S. Virgin Islands. In Georgia, that compact is statutorily enacted in OCGA 39-4, sections 1 through 10. All right, and slide 3 that is on your screen right now, this shows the number of cases processed by our ICPC unit in fiscal year 2025, where Georgia is the receiving state. Thus far in fiscal year 2025, it is just over 1,600 receiving cases. Of this amount, almost 77% are public matters, parent, relative, foster, and public adoption. 282 or 17.5% were residential changes, i.e. when a foster child is moving into the state of Georgia into a residential setting or a different residential setting. And 90 cases, or about 5.6%, were private adoption cases. Next slide. On this next slide 4, this shows the number of cases processed by our ICPC unit in fiscal year 2025, where Georgia is the sending state, meaning the child is leaving the state. The total for this year so far is 863. Of that amount, almost 71% were public matter moves. 187 or 22% were residential changes. And then 68 or 6.39% were private adoption cases. Combined, the ICPC unit has processed almost 2,500 sending and receiving cases in fiscal year 2025 thus far. A majority of them, a large majority, almost 75% have been the public. About 19% have been residential changes, and 6.39% have been a private or agency adoption matters. And this latest slide, the ICPC process is a very basic and high view. It just starts with a case initiation where a sending state submits a placement to its state ICPC office. That ICPC office gathers all their information into a packet, sends it to, if it's coming to Georgia, to our ICPC office. At which time, if it's a complete packet, our local or state ICPC office will accept it and forward that, they will forward that packet to us, we will accept it, and then we'll immediately initiate a home study. Thereafter, we'll make a decision on this case where we'll notify the sending state of our approval or denial of the placement. I'm going to assume that we did an approval on this, and at that point in time, then the monitoring begins where the child is placed in the receiving state, and the placement provides regular updates to the sending state on the status of that child. So if Florida sent us a child, we would go out there, I believe every 120 days, and do a status check on that child and provide those reports to the state of Florida. State of Florida does continue to have jurisdiction over the child while they are in the state of Georgia. And prior to me handing this over to Mr. Adigan, Senator Hatchett, as far as your question on the bordering states and the revised compact, only one other bordering state, Florida, has enacted statutorily the revised. Alabama, Tennessee, North Carolina, and South Carolina have not.
And maybe this is a bad assumption, but I'm assuming if there were, the movement of children across state lines, the majority of them will be to our neighboring states. Is that correct?
Correct.
So it'd be good to encourage our neighboring states to get on board.
Oh, I agree 100%.
That's kind of where I was getting at. Thank you.
Good morning, Chairwoman Kirkpatrick and members of the committee. My name is Aladejola Adigan, and I serve as the Director of Policy Implementation within the DHS's Office of Health Law and Policy, and as the Compact Administrator for the Interstate Compact for the Placement of Children. Thank you for the opportunity to address you today. I'm going to cover the placement types under ICPC regulations and the expected timelines for processing. The first regulation type I'm going to address is Regulation 1, which governs the relocation of relatives, foster families, or adoptive families in situations where there has been an approved placement from a sending state. So for example, a relative, foster family, or adoptive family that already has an approved placement from Alabama would move to Georgia under this regulation type. Under this example, a child would already be in the home when our DFCS caseworkers go into the home to conduct a home study. The next regulation type I'm going to address is Regulation 2. Regulation 2 governs the interstate movement of a child to reside with relatives, foster families, or adoptive families in a situation where there has not yet been an approved placement from a sending state. So under this example, when our DFCS caseworkers go into the home to conduct a home study, the child is not yet in the home because placement has not yet been approved by the sending state. Most of our intakes fall under this regulation type. The next I'm going to address is Regulation 4. Regulation 4 governs placements in licensed residential facilities or institutions like child caring institutions, commonly referred to as CCIs, and in psychiatric residential treatment facilities, commonly referred to as PRTFs. Home studies are not conducted for these placements because they are for approved and duly licensed residential facilities for children. Before completing placement, however, we do ensure that a facility is in good standing. There is a database through which our ICPC staff conducts checks that facilities are in substantial compliance with enforcement regulations. The next regulation type I'm going to address is Regulation 7. And Regulation 7 allows for expedited and priority placements in certain situations, including emergencies. The following situations could constitute emergencies worthy of a Regulation 7 request. One of those is an unexpected dependency due to a sudden or recent incarceration, incapacitation, or death of a parent or guardian. Second, when a child who is sought to be placed is 4 years old or younger. Third, when a court has found that any child in the sibling group sought to be placed has a substantial relationship with the proposed placement resource. And fourth, when a child is currently in an emergency placement. Those 4 situations could trigger a Regulation 7 placement request. At this point, I'm going to address the processing timelines under each of these regulations. For requests under Regulations 1 and 2, from when a case initiation packet is sent, we have up to 3 days to request a home study. From when a home study is requested or assigned, we have up to 45 days to complete that home study. From the home study completion, we have up to 3 days to transmit the decision based on the home study. And the decision can be either an approval or a denial. If an approval is granted, we have up to 180 days to actually place the child in the approved resource. I just want to make a note here that for Regulation 1 cases, we don't need to wait that 180 days for placement, again, because placement has been approved from a sending state. Now for the processing, I'm sorry, you have a question.
Yes, ma'am. Thank you. Very quickly, can you explain why it would take essentially half a year to transfer someone after they've already gone through all of these processes? Can you just explain that very wide window?
Yeah, sure. We have, it's an up to, it's not, it doesn't have to take 180 days.
Sure.
We just give a sending state a maximum of 6 months to essentially use the approval that has been granted. If they want to place outside that 180-day time period, we have to restart the process all over again.
But in the event that Georgia is the sending state, you also have 180 days to.
Correct. Most times the placement doesn't in fact take 180 days, but we have up to 180 days to use that approved placement.
Can you explain why there would be delays? That's my question.
Well, the delays can happen for a number of reasons. Maybe they don't need that resource anymore. Maybe the resource changed their mind. Maybe they're still figuring out the logistics of whether they want to move across state lines. But in that time, while they're making that decision, the clock is running.
Okay.
Yeah.
Thank you, Madam Chairman. Now, just to follow up, I recognize that you have up to 180 days to complete a placement. What is your average placement time? Do you have an average by category? So category 1, 2, 4, 7, any ideas? How long would you anticipate it to?
We would usually anticipate placement to happen within 60 days. That's what we've been seeing within our office. But again, the 180-day timeline is only the maximum
I got
within
it.
which.
I got it. And I would suggest that 60 days is more reasonable than hopefully we can achieve those types of numbers or even better.
Yes,
Yeah.
Senator, and there are a lot of other factors with regards to classes that the placement needs to take.
Mike.
Sometimes it's
Mike.
There are certain classes that a placement may have to take before the placement is finally approved. And sometimes there are issues with them enrolling in the class and keeping them on the timeline that these cases can happen within a relatively expedient amount of time.
Thank you.
Okay, please go ahead.
All right. I'm going to address the processing timelines for Regulation 4 cases. Again, Regulation 4 cases are cases where placement is happening in an approved institution. From the date of receipt of a request, we have up to 3 days to either approve or deny the placement. And after approval, we have up to 30 days for placements to actually occur under Regulation 4 types. Again, home studies are not required in these cases because the institution within which the child will be placed is already an approved institution. Now, under Regulation 7 types, we have from the case initiation packets, we have up to 1 day to assign a home study. From home study assignment, we have up to 15 days to complete the home study. From the home study completion, we have up to 3 days to transmit the result or the outcome of that home study. And if it's an approval, again, we have up to 180 days to actually use the approval by placing the child. ICPC is critical for child protection. And I thank you for your attention and your commitment to improving child welfare in the state of Georgia. Before I pass it on to Ms. Krim to discuss private adoption specifically, Mr. Pedersen and I will be happy to address any more questions you may have for us.
I think you're good. Thank you. Ms. Krim?
Thank you, Chairwoman Kirkpatrick and committee members. My name is Dina Krim.
Yeah, scoot your chair a little bit closer so.
I can do that. The first time I testified before you all, I was asked to give an overview of a dependency case from removal to termination. Today, I'll be speaking on another child welfare issue that has generational impact on families, and that is interstate adoptions. An interstate adoption occurs when a child is born in one state and adopted by a family that lives in another. ICPC Article 7 empowered ICPC compact administrators from around the country to promulgate regulations to provide estates with detailed guidance. Regulation 12 covers private agency and independent adoptions and was adopted in its current form in 2012. OCGA 39-4-1 gives Georgia Department of Human Services the authority to process interstate adoptions. The typical ICPC Reg 12 adoption follows these steps. The adoptive parent travels to the birth mother's state for the birth mother signs surrenders, and the baby leaves the hospital with the adoptive parents, with the understanding that they will stay in the birth state until both states have given their approval. I'd note that NICU stays are not uncommon, and ICPC packets aren't submitted until after the baby has left the hospital. It typically takes several days post-discharge for the attorney to get the packet documents prepared and submitted to the sending state ICPC admin. If approved, the sending state sends the packet to the receiving state. The receiving state admin then has their turn to review the packet and communicate their approval or denial to the sending state. Both state admins may request additional documents at their discretion. Between hospitalization, packet preparation, transmittal time, and agency administrative review ×2, not to mention intervening weekends and holidays, the out-of-state adoptive parent should be prepared to spend time in the sending state. The full text of the ICPC Articles and Regulation 12 have been included in your packets. You'll see Regulation 12 is 5 pages long. The typical ICPC packet is, by contrast, typically at least 100 pages long. Regulation 12 gives the receiving state 3 business days to review the packet and approve or deny the adoption request. There is no such mandate for the sending state ICPC office. Nevertheless, Georgia strives to review all Reg 12 requests within 3 business days and succeeds in doing so the vast majority of the time. Reg 12 is silent as to the reason for imposing processing and approval timeframes on the receiving state, but not on sending state admins. But I suspect it has something to do with the stated intention of Regulation 12. Quote, "The ICPC process exists to ensure protection and services, not just to children, but to families involved in executing adoptions across state lines. It is further the intent of Regulation 12 for the sending agency to comply with each and every requirement set forth in Article 3 of the ICPC," end quote. when a Georgia baby being sent to an out-of-state family for adoption, it is our job at Georgia ICPC to ensure that the parties involved comply with the ICPC and applicable Georgia law. It has been suggested that the role of Georgia ICPC is superfluous because Georgia Superior Court judges review and have final say over adoptions of Georgia-born babies. I personally wish that were the truth, but a significant percentage of outgoing adoption requests submitted to Georgia involves parties planning to finalize the adoption in another state, using that other state's law, meaning that no Georgia judge will ever have the opportunity to review the circumstances of the adoption or make a determination of what is in the best interest of the Georgia baby. I know this because since last fall, I have been a second set of eyes to review outgoing packets, especially those involving birth parents who have waived Georgia birth parent protections, such as the 4-day revocation period to change their mind or the right to an enforceable post-adoption contact agreement. At Commissioner Brose's request, I have been happy to advise and work with our Georgia ICPC professionals, and I am grateful to be here today. As an adoptee myself, my experience with adoption has been beautiful, but I am betting you have all read media reports highlighting adoption practices that have caused trauma and pain to the parties involved. Protecting birth parents and children requires adoption agencies and attorneys to be held to the highest professional standards. One way Georgia has endeavored to do this has been via updates to our ICPC checklist. Georgia's checklist was intended to be a tool to help Georgia adoption professionals and, quite frankly, our own agency personnel. Georgia's checklist was never intended to take the place of Regulation 12 requirements. It was revised to include greater specificity because so many packets were missing necessary documents and misinformation. So I concur with Mr. Masters that the number one reason for the delay in ICPC processing and approval is submission of incomplete packets. Just last week, a prominent adoption attorney from Georgia submitted an outgoing request with the required one-page fill-in-the-blank with basic information form called 100A. The form submitted was missing all information. Every box was blank, except for the box with mom's signature. Inadvertent mistakes like this are inevitable, and they do cause delays. And sometimes those delays are, in my opinion, unfairly attributed to ICPC staff. The last slide and this current slide show two examples of changes that have been made to Georgia's checklist to align more specifically with the language of Regulation 12. I'm not going to read those slides to you, but I do want to highlight on this current slide, you can see that the attorney or agency representative submitting the packet must disclose in their cover letter how the birth mom was matched with the adoptive parents and identify the name of any intermediaries. Parties that submit cover letters without required information are now being asked to submit an amended one. You'll hear more about the match process from RCCL, Ms. Beth Vineyard, but I wanted to highlight that included in your handouts is a September 2024 public notice from the Federal Trade Commission warning adoption intermediaries against misleading parents and engaging in deceptive or misleading conduct. Your handouts also include a copy of the template FTC warning letter that was sent to 31 adoption intermediaries across the country. I would like to close by sharing that the colleagues I'm sitting with today and the ICPC administrators that work under their leadership are hands down among the most hardworking agency professionals I have encountered in my 18 years as a SAG. They are consistently responsive, evenings and weekends included, and I promise that they are working diligently to process requests as expeditiously as possible, united in the conviction that every birth parent deserves to have peace of mind for the rest of their lives, that their child that they gave up is being cared for by a loving parent with the ability to care for their child's specific needs. And every child deserves to be placed in a home with fully vetted caregivers that have been approved. Thank you.
Thank you. Questions from the committee? Senator Payne?
Thank you, Madam Chairwoman. I did have one question. Having worked with juvenile courts for 30 years and dealing a lot with interstate compact. But Mr. Williams he just briefly toward the end of his, and I wanted to wait till y'all were up here with the attorneys to talk for Georgia. How do we take into consideration for those who are Native Americans, being from North Georgia and New Echota area? Where does that play into the timeline as far as?
Well, I will say that Georgia is one of the states that doesn't have any registered tribe in our jurisdiction, but it is a requirement that they have to, that's a requirement of Georgia law that ICPC is checking to make sure that there is an ICWA letter saying that there is no chance that the child is eligible for membership in a tribe.
Okay.
And I'm personally not aware of any packet that has implicated ICWA.
Well, that just caught my attention. I just thought I should ask.
I'm glad you did. It is on our checklist.
Senator Burns?
Thank you, Madam Chair. Following back up, really going back to Mr. Peterson's early presentation, on slide 5, we talked about acceptance, and we keep hearing the issue of incomplete packets, incomplete application packets. What percentage of the applications you receive are deficient?
Senator, I can go back and get you an exact number on that with the amount and the nature of the team. And when we're talking 2,700 packets that come in.
How many coming in, how many going out, sending versus receiving?
I do not have that number. in front of me.
2,700, I think was total. Is that right?
Correct.
1,600 or so going out, which would mean 900 or so coming in. Is that right?
About 800 coming in and about
Okay,
700
so
going out.
roughly, so
Yeah.
we've got about 2,700, I don't know, 1,600 or so going out, 800 coming in. What percentage would you guess or estimate, not guess, but estimate would be deficient and you would not accept you couldn't even start the process?
I do not have that information with me right now. I'd be happy to supplement it for you.
Yeah, I'd appreciate that because I think that's important for us
I-
to know what percentage of this work you can't even begin because you feel that there's not.
I agree, Senator.
If you'll send that to me, I'll get it to the committee.
Thank you.
Yes, Chairman.
Can I answer that as to Regulation 12 adoption cases specifically? I believe we have, the majority of them, I would say, are incomplete or missing information, but with the caveat that Reg 12 cases specifically are submitted on a tight time frame, right? Because the adoptive parent is anxious to leave the state. The other types of requests don't have that tight time frame for preparation for submission. And when they are incomplete, our policy is that we communicate what is missing back and ask for that to be supplemented.
Thank you. Senator Mallow?
Thank you, Madam Chair. I just had one question. I know we talked about infants and adoption. In the ICPC, is there anywhere that there's a requirement for a guardian ad litem to represent the interests of the child in any of these adoption cases to ensure that the interest of the child is represented separate from the interested parties?
There is not, and Georgia law also does not require that the birth mother have independent legal counsel or even that the surrender documents be witnessed by an uninterested party.
And my last question, if the same attorney represented both parties, is there something that that adoption attorney has to sign to attest that he's explained or she has explained to that parent that there could be a conflict and that they're waiving that right to have this type of representation?
There is something that is called a petitioner's affidavit that the attorney has to sign stating that they explained the paperwork to the parent and that they believe the parent is not under any undue influence or duress at the time of signing. But that affidavit does not specify that that they explained the right for them to have independent counsel, but that is something that is in Georgia's affidavit, that the standard affidavit form that the legal mother signs. But that is not necessarily something that if the birth parent decides to use another state's law, because that's what the adoptive parent has, preferred or presented to them, then that's something that we're looking at when we look at the surrender documents that are submitted, that from pursuant to another state's forms.
Okay, thank you.
Senator Islam Parks.
Thank you, Chairwoman. First of all, thank you so much for all the work that you do for Georgia's children and families. And my question was, so all three of you here are the ones that review the ICPC packets?
The ICPC packets that come in get reviewed by, we have about 8 other staff members that review ICPC packets, both incoming and outgoing. And they pretty much divide the work based on whatever letter begins the last name of the child at issue.
Okay. And has it always maintained around that number, like 8 staffers that are to help with this?
Thereabout, yes.
Okay, thank you.
Senator Estevez.
Thank you, Chairwoman, and thank y'all for this information. I have a question about compliance and accountability. I've worked in a space where you have a lot of timelines and you've presented a lot of timelines, a lot of different requirements. Does your team and the department as a whole have a dashboard to keep track of key performance indicators? Like how do you all ensure that that timelines are not slipping, that something falls to the floor and people forget, and ensure the accountability on that side?
Senator, those statistics are tracked as far as the number of days that a case has been within the office right now. I mean, I'll admit right now, I don't love the current format on it. I, like you, like metrics and performance idea or performance improvement goals on it. But if you would like to see that, we would be more than happy to produce that to Chairman as a supplement on that. So you could see currently what the status is on every pending case currently.
I don't need to see it. I was just curious to hear more about how y'all manage through that compliance system. So I hear that you have.
It's tied to each administrator who reviews it and their caseload, and everyone is timed at a 30, 60, 90, 120, 180 day interval on it and within the current tracking right now.
Right. And then does the team have a record management system that keeps track of open, closed?
Yes,
Keeping track of that time. Is it
through the compact, there is a universal system. It's called the NEAS system, and that is how. Now there is one little issue. There is a NEAS system, and then there's another option for another. So not all the states use the exact same tracking system, but a majority use the NEAS system, which is what we use here in Georgia to do that. And that is how these packets are transmitted between state to state.
And last question, really quickly, related to your prior comment, is that system up to date and user friendly, and helpful, or is it outdated and something that needs to be?
It is, and it actually is going through a revision right now. And there are actually things within our own agency that our IT team is working on to improve it so that it is easier to use and more functional than just keeping sending data back and forth.
Thank you.
Thank you, Senator Hatchett.
Thank you, Madam Chair. Well, first, I want to echo what Senator Islam said. Thank you all for what you do and for being here today. I think it shows the importance of this issue with the number of committee members that are here. If you're around during session, sometimes we, in other committees, you struggle to get a quorum, but I think we're all here because we care about this issue. And what I really want to do is I want to help, I would like for y'all to help us identify issues that we can assist and not just throw a Band-Aid on the situation. We've got several, we got a affidavit in our packets and I guess narratives from past cases. And one of the main things that they tend to identify as problems are just delays and issues with, I guess, stricter requirements in Georgia than other states. While I understand the policy behind there's obviously, we want to make sure that we protect the children and we, cross all our T's and dot all our I's. But I guess when I'm looking at the couple slides here where there were the former Georgia ICPC checklist and then the current Georgia ICPC checklist, are there things that can be done to, I guess, help streamline this process, whether it be, going to a more digital type system? It sounds to me like it's all paper right now. And I guess this is a two-part question: is when did these current changes for the checklist, when did they go into place?
Just recently.
And
Like how recently? Sorry.
I should add that the language at the top, where it says what is an ICPC cover letter and quote, request for approval, that quote comes directly from ICPC Regulation 12. So the point of that was to show that is what the Reg 12 has required and has been in place since 2012, and how our checklist that was changed most recently in October, and now there is a streamlined one, but the October checklist has language that mirrors more closely what the ICPC reg has been saying has required since 2012.
So the checklist or the current Georgia ICPC checklist, is that a checklist that's generated by y'all, or is that something that's sent from ICPC?
It was meant to be a tool
Right.
to like give a bullet point list so that adoption professionals submitting them can kind of check off, and for our own admins who are lay people, not lawyers, can review and check things off. And we have a more streamlined one that has gone public on the website that is short.
And it is modeled after what our sister states are doing to make it more efficient for not only practitioners in it, but for the general public in this area.
And I hope you,
And as far as like impediments, that's a large question that takes a long time. But technology in and of itself won't solve and the delay issues. There is areas that we're addressing and that Mr. Adigan and I have been working with, to where you get situations, let's say, in the Atlanta area, it probably would not be an issue, but there's definitely a workforce component to it, to where you get outside of this area and you have DFACS offices that are staffed. Now, these home studies have to go through our local county offices to do that. So in addition to all of their normal case management and others case staffing that they do, in addition to court appearance, doctor visits and everything like that, they may get a ICPC home study on it and have to fit that into their workload. Right now, we're working on a system to propose to Commissioner Brose for her consideration on improvement of that system. I think it's premature for me to go over it in an open hearing exactly what we're going to be doing right now. But I can tell you that that is being seriously thought out and addressed. We have talked to several different regions and several different counties to learn how they do it, their impediments, and figuring out an idea, the most reasonable way to address it. Technology is a portion of it, but I don't think we can just say, let technology do it. I don't think it's also an issue where we can rely upon a contractor to do this work on behalf of the agency, because it does require social service hands-on these home studies because of the importance of the outcome of them.
Okay. And I just hope you realize I'm not coming from looking at this through the lens of y'all are doing something wrong or anything.
I
We just want to identify the problem. And in one of our packets, there's a time frame at the end of 2023 where this seemed to, I guess the delay seemed to begin. Is that when any of these current checklists were implemented, or is there something that happened towards the end of 2023 that we could kind of go back and look at, or is that just a coincidence?
No, I think that the checklist became a little, in my opinion, a little overburdensome and maybe too detailed as to what it was on it. We have changed that checklist now. And again, I can't go over all, or I don't have the ability to give an opinion on what exactly went into it at that point in time. All I can say is that under our office, we have addressed it. We're going to continue to address it on it. And the ultimate goal of it is to not just improve our timeline, but I seriously want Georgia to be the #1 state for adoptions so that it's easier here. That's my goal.
And I hope we are here to help with that as well.
Okay, we've got 2 more questions. Can you guys make it quick, Senator Payne?
Yes, my question was just real quick. If you could change one thing to make this better, make it faster, what would that one change be?
How deep are your pockets, Senator?
Yeah, deep.
That's
No,
that's
I
all.
don't think that there is one thing, because there are so many outside components to it. You have outside parties, you have the case studies, you have the parties involved themselves, and you're not only dealing with paperwork in and of itself, and I'm just talking about as a generalization of all these cases. You're not only just talking about whether the employee at DFACS is doing their job and expeditiously reviewing these. You're talking about also basically case managing the individuals involved, their access to complete the task that they need to do in order for the approval. So I don't think that there's like a one, silver bullet that's going to solve all of the issues. It's going to be a combination.
Senator Islam Parks, quickly, please.
How recently did you guys update that checklist?
We just updated the checklist and released it on our website. I believe it went live. The checklist went live on Monday.
Oh, wow. Okay. Does it still require the review of the entire medical record of the mother?
Well, it is, Senator, in there. It does not require it, but all of these are done on a case-by-case review. And the agency, as its discretion, does have the right to ask for that information if it deems it necessary.
Thank you.
Thank you.
Thank you all very much. We've got another team from DHS coming up right behind you. And then we've got a lot of other people to testify. So let's try to keep it moving.
Thank you all.
The next subject is licensing and unlawful child placement activities. Ms. Quick, you ready?
Don't think I can start without my compatriots here.
Okay, there you go.
But good morning, Madam Chair and Senators, while they're getting set up. Thank you for this opportunity. We will start with you looking at a little organizational chart, and I'll just tell you how I came to be sitting here with these folks from the Office of Inspector General, which is within my part of the organizational chart. Right after the legislative session in 2024, I was contacted by some private adoption attorneys, including my good friend Sherry Ann Hicks, regarding some of the timeline delays, the issues that you all have heard about and Senator Hatchett alluded to. One aspect of this involved a rule that is in your packet. And that is an interagency agreement requirement for out-of-state agencies that are operating and conducting placement activities in Georgia. So after that meeting, in-person meeting in May of 2024, we shifted internally the enforcement back to, in my view, where it should be, because these are my licensing folks that deal with our child placing agency. So effective July 15th, 2024, you'll see in your packet a memo that went out to all of our Georgia agencies and was placed on the public-facing website of the agency at that time. Just briefly, I'll introduce for you here today with me Maurice Ingram, seated over there on the end. He's our 5th Inspector General and our Assistant Deputy Commissioner, but I just mentioned that Maurice is a 20-year veteran of DHS, most recently serving as our Deputy Inspector General, heading up the Benefit Integrity and Recovery Unit, and is a certified Inspector General by the Association of Inspector Generals since 2022. And glad to be with him as our 5th Inspector General for the agency. Beth Vineyard, you see her job title there, but I sharply salute her as well, and you'll hear why in just a minute. She has held this position for 4.5 years, and prior to that time was the Director of Foster Home Development for one of our CPAs, Faithbridge. Her previous tenure was with DFACS as a case manager in the 90s, and she's worked in the child welfare space in 3 different states during that time frame, and simultaneously served as a Medical Service Corps officer in the Army National Guard for 12 years during some of that time. And she heads the Residential Child Care Licensing, or RCCL, of the Office of Inspector General. And she's going to present to you today what our process is involving dealing with out-of-state agencies and our own Georgia licensed agencies. Beth?
Good morning. I'm honored to be here today. Oops, let me see if I can get this. All right, I think I just did something wrong. Let me see. All right, there we go. Can you hear me? Okay, there we go. All right, we're going to go ahead and get started with defining. Georgia law defines a child placing agency, or as a CPA, as any institution, society, agency, or facility, whether incorporated or not, which places children in foster homes for temporary care or for adoption. Department of Human Services rules further clarify that an entity that engages in placement activities are required to be licensed as a child placing agency. And currently we have 105 licensed child placing agencies across the state. The penalty for operating an unlicensed CPA is a misdemeanor in Georgia, and that entity can incur a fine of between $500 and $1,000 for each such offense, and each day of operating without a license shall constitute a separate offense. Okay. No person can advertise that they will adopt or arrange for or cause a child to be adopted or placed for adoption unless they're in one of 3 categories: a child placing agency, a prospective adoptive parent who has a valid approved home study, or a Georgia attorney representing a prospective adoptive parent with a valid approved home study. The penalty for unlawful advertising of adoption services in the state of Georgia is a felony. Inducements mean any financial assistance, either direct or indirect, from whatever source, except for the following expenses: medical expenses, which include that are directly related to the biological mother's pregnancy, hospitalization for the birth of the child, and medical care if it's paid for either the CPA or the attorney, not from other means. Expenses for counseling services or legal services for the biological parent that are either directly related to the placement by the parent for his or her child for adoption, if paid by the CPA or by the attorney, and reasonable living expenses for the biological mother, if paid for by the CPA, or reasonable expenses for rent, utilities, food, maternity garments, and maternity accessories for the biological mother, if paid for through a trust account from a Georgia attorney. It's unlawful in the state of Georgia to hold out inducements to any person, to any parent, to part with his or her child. It's also unlawful in the state of Georgia to conspire with another to offer to provide inducements to a parent to part with his or her child. And it's also unlawful to knowingly make false representations in order to obtain inducements. And the penalty for doing any of these is a felony. How residential childcare licensing responds to statutes that are passed by the Georgia General Assembly is through our rules and regulations. The first rule on the screen has been in effect since at least April of 2000. It reiterates the law by stating that no person or entity shall engage in child placement activities, including the advertising of such placement activities in Georgia, unless they're licensed by RCCL. It goes on to state that it's CPAs that are licensed in other states and wishing to engage in placement activities, including the advertising of such activities in Georgia, shall either also be licensed in Georgia, or they're going to have a written agreement with a CPA in Georgia. And that agreement is going to state that they're going to cooperate with and supervise the placement. The agreement shall be approved by the department prior to placement.
Can I just a second? So I do want to reiterate, this was not a new rule in 2024. There's been some discussions about new requirements and new rules that were made. As you just heard, this is a rule that has been in place in the agency for some period of time. What was new was, I guess one might say, there was a new sheriff in town, in that the OIG was the group within the agency that was actually trying to meet quick timelines and communicate with the agencies involved.
Sorry. What year did you say again?
Since at least April of 2000, that's as far back as we could find that it was written in there, but since April of 2000, it has been in our every single rule since then, this exact wording. So the term placement can have a variety of meanings. So for these purposes, the CPA rule defines child placement or placement activities as the selection by a person or the agency other than the child's parent or guardian, or a foster family, or of a foster family or prospective adoptive parents, or affecting the movement of the child into the foster family or prospective adoptive family. The definition includes preparation of a home study of a foster home or prospective adoptive family. The definition, counseling with respect to adoptions available, legal services or services as an agent for the purpose of notice of revocation of consent by the biological parent does not constitute child placement under this definition. The interagency agreement, or the IAA, is what we call the agreement between the out-of-state CPA and the Georgia CPA who are working together for an interstate placement. There are two components to the IAA. The first is that they must cooperate with each other. And the second component is that the Georgia CPA is going to supervise the placement activity of the out-of-state CPA. And remember that the IAA must be approved by the department prior to placement activities occurring. RCCL conducts an administrative review of all IAAs, and since July 15th of 2024, RCCL has received 130, approved 76, withdrawn 2, had no jurisdiction of 51, and denied 0. Now these stats were as of last week. We've actually changed by 4 this morning.
Excuse
Did
me,
you have a
Ms.
question?
Junior, what do you mean by no jurisdiction?
I was getting ready to explain exactly what that is. So no jurisdiction cases are when either a CPA is licensed in Georgia and in another state. Again, part of the rule says that you can be licensed in 2 states. So you may be licensed in Georgia and also licensed in, say, Florida, for example. So we would not have jurisdiction in that case. Or when the placement activity is not being conducted here in Georgia, it may be conducted in the other state. So in that case, we would not have jurisdiction to give authority because it's not part of our jurisdiction. RCCL works with the CPAs involved in order to obtain information with what we need in order to make a decision in an effort not to deny any IAAs, and therefore we've had to not deny any. In cases of the 2 withdrawn cases, they were able to resubmit them and gain approval. RCCL makes a decision about these IAAs within approximately 5 business days. There are 2 types of IAAs. One is child specific. In those, we're giving approvals for 1 year, but it's only good for that child and for that adopted placement. There can also be a generic or a general type of IAA that is good also for a year, but you can do unlimited adoptions or placements between the 2 agencies. RCCL is recommending general agreements between 2 CPAs that routinely work together so that CPAs can ensure that there are protocols and memorandums of agreements in place well before placement activities occur and before the ICPC process is even needed. Since July 15th of 2024, RCCL has conducted 21 investigations that resulted in citations to entities for conducting unlicensed child placing activities. 17 were cited at the substantial compliance level. 4 were cited at the initial category 3 level, which is a higher level. In the cases when RCCL cited at the substantial compliance level, we felt that most of the out-of-state CPAs didn't know about our rules that required the IAA. The lower level citations were given as a type of warning and an education to the other CPA. In the 4 cases where RCCL cited at the higher level of an initial category 3, we felt that the entity knew about our rules or had been previously warned about them, and that the entity was being deceptive and had intent to violate our rules and regulations. The chart shows how many times we've had to cite the entities per month since July of last year. As you can see, the number is trending downward. We believe that the trend is because of education of our rules, and we hope that the trend will continue to keep going down. Starting next month, RCCL will send an annual report to the Attorney General's office and any appropriate law enforcement agencies regarding unlawful child placing activity. Yes, ma'am.
Yes, thank you, Madam Chair. So I would like to know what happens. So with the 17 lower level situations, there were adoptive parents who were in the process, I'm assuming, submitted ICCP. That's how it got on your radar, right? Like I know the story, right?
Yes.
And so what happens to those adoptive parents and that infant when you discover that they're one of those 17 that don't have an IAA? It's not the adoptive parents' fault. Like they don't know. So what have we done to resolve that particular issue and to make sure that families can continue to be united, even in the event that somebody was behaving, an agency beyond their control was behaving outside of our orders, our rules?
So typically, our agency, when we're doing an investigation, we have 45 days to complete investigation. We do not want to hold families up for 45 days. We know these families are sitting in hotel rooms with an infant. That's not ideal for anybody. So we don't want to do that, especially when we feel like, the substantial compliance, they're kind of caught in the middle. And again, we feel like in a lot of these cases, agencies just didn't realize what was going on. So we have shortened that time frame. We've actually been doing a modified investigation where we complete that within 1 business day. So we can go ahead and do that, and we give that substantial compliance citation, and then about 5 minutes later, they get the approval to go ahead and that approved interagency agreement. We are also copying the ICPC office on all of our determination letters. So all those 130 that we've done, we copy them on that. So therefore they had that immediately. So that helps with that lessening of the paperwork. So they get it directly, so that if for some reason the CPA forgets to put that in their packet, they've already got it at their office.
And when were you all able to implement this one business day protocol?
We started that in July of last year. As soon as we got it, we realized from the numbers immediately, we put our heads together and immediately figured out this was not going to work to do the full 45 days. So we modified it immediately.
Thank you.
Thank you, Madam Chair. As I read some of the affidavits in here, I talked with my colleague to my left and my right, Senator Jackson, and Senator Hatchett. Is there any opportunity where we could require that the mother is putting the child up for adoption have counsel that's paid for by the folks who are adopting the child, ensure that they have proper representation? I mean, here I read an affidavit where someone was Vietnamese, and I'm certain it said they were undocumented, and so that means they probably didn't speak English. So how can I attest that their interests were represented and they understood everything that they signed? If all these forms are in English, how would they have known what they signed?
So, Senator, I think we can take that back as an opportunity to give a response.
Yeah, I don't know that from an RCCL standpoint, from their licensing standpoint, probably no opportunity for them, but there's an opportunity for you all to put that into the law as a requirement if you wish. That would be my short answer to that. And I'm happy to look at that further and research that further with Ledge Council and the chairman, with you, Senator Mello, whoever would like to look at that.
Yeah, thank you. So just a point of clarification. When a birth parent decides to sign away their parental rights with the intention of an adoption, who has to be present for that signature? Does it have to be notarized? Does there have to be an attorney that explains it, or some other person that can testify that they've explained it and that the person is signing not under duress? Like, I mean, I do weddings all the time and I have to actually ask, are you getting married under duress, right? Like, that is a part of the process. And so is that built into this adoption process or not?
Senator, as you know, I'm a recovering family lawyer.
I'm aware.
And I didn't do a lot of private adoptions even when I was a practicing family lawyer for all those years. So I'm going to defer to, I think the adoption lawyers are on the agenda here. I'm going to defer to that. But I would say that from my perspective, not speaking for the department here, but speaking as an attorney who operated in this space, that that would be a good thing to look at to protect those birth mothers from these situations. These acts are called baby broker acts generically in family law circles for a reason. And y'all have these laws on the books. We have these laws on the books for a reason. But I would say in particular, since there are adoptions being finalized, it's my understanding, since the law changed in 2018, the adoption code, there are adoptions being finalized by people who are coming into the state only to do the adoption, meaning that act eliminated the venue requirement of the 6-month venue requirement for adoption. So you don't have to be a resident of the state of Georgia to do an adoption in Georgia. And to previous questions and previous points, if you've got someone who's coming into the state just to do the adoption and nobody may have a real connection to Georgia, there's no real supervision then of the placement or analysis of the placement that may be sitting in the hotel room waiting to go to another state when the adoption is finalized. So, and your adoption code also does not require, my understanding, those adoptive parents to even be present in the courtroom for the supervision of a judge. I think there's a preference, maybe even a presumption that they can participate, virtually. So
That's one last follow-up question. I feel like we're trying to solve for a problem I'm not clear exists. Are there adoptive parents out there posing as adoptive parents and seeking to do harm and steal people's babies? Like, what are we trying to solve here for? And I say this, I'm kind of emotional about this because I had to go to Indiana to get my child and they didn't make me do a whole bunch of stuff to get my baby, right? So I just want to understand, are babies being stolen? Are they being trafficked through official adoption channels? Is that what you're suggesting that we're trying to solve for to eliminate?
well, from the perspective of our licensing, I'll ask Ms. Vineyard to go to the next slide. And so this is sort of one of the circumstances in the categories that we're looking to figure it out, I think is the best way I could say.
So I'd like to share the details of an investigation that we cited earlier this year at a higher level. The name of the organization is A Birth Mother's Choice, but they also go by the name of Adoption Advertising. There was a pregnant woman in Georgia who found A Birth Mother's Choice through an internet search. A Birth Mother's Choice is not a licensed child placing agency. They also hold no business license that we were able to find in any state that we looked up. The woman received money directly from A Birth Mother's Choice. She met some prospective adopted parents that were from out of state at a local coffee shop. She talked with an adoption attorney, but she did not know his contact information, couldn't get in touch with him or couldn't share it with us. Was told that the birth father did not need to be involved, and he most definitely was involved. He was involved with her. He was involved in this unborn child's life. A Birth Mother's Choice was being questioned over and over again about the race of the baby. When we got involved and started investigating, looking into it, she told A Birth Mother's Choice about it, and the Birth Mother's Choice told her that we were a scam, that our investigation was a scam. A Birth Mother's Choice, when we reached out to them or tried to reach out to them, we called them on the phone number that was on the website. They didn't return our phone calls. They had an email us portion of their website. We filled that form out. They didn't return it. There was no physical address on their website for us to get in touch with. We were able to track down a similarly named legitimate child placing agency. And because of the similarly named agency had constantly gotten complaints about this A Birth Mother's Choice, they knew some information and were able to point us in the direction of the actual agency we were investigating. A Birth Mother's Choice is under investigation by the Virginia Department of Social Services. They are located in Virginia. The Division of Licensing Programs, and RCCL is cooperating with that investigation.
So, Senator, if you'll go to the next slide, Ms. Vineyard, I don't know that I've got the tools at our disposal to tell you exactly what is going on in circumstances like this, because as this committee knows, as we've discussed before, we don't have any law enforcement powers or anything like that to do much of anything when it comes to this other than investigate and turn it over to law enforcement, which we will at the appropriate time and work with other authorities. These are our enforcement mechanisms in the RCCL, in the residential child care licensing world. And we have the right to ask a judge for an inspection warrant. And if you're looking at possible anomalies in the law, I just call to your attention that next code section. If we go to the trouble of getting an inspection warrant and uncover something like you're talking about, it would the facts and the evidence would be inadmissible in any subsequent criminal proceedings. I'm not sure what the merit of that is, but that's about all we can do, is investigate and do the best we can to gather the facts and cite folks who need to be cited and turn it over to district attorneys and the attorney general at the appropriate time.
Okay. Are you guys finished?
You are.
Okay.
Just try one more bite at that. Thank you, Madam Chair. I don't feel like my question was actually answered. Again, I'm trying to understand, what are we solving for? So we can even take the example that you gave of this non-licensed agency. Are children being harmed? Are birth mothers being exploited? What are we solving for by adjusting these rules and regulations, should that be something that we choose to do?
From an agency perspective, and specifically from an RCCL perspective, we're trying to enforce the laws the General Assembly has passed. And that's why we started first with the slides on unlawful advertising, which you have specified is a felony, and unlawful inducements, which you've specified as a felony. So I don't know that we're trying to solve the problem so much as we're trying to enforce the law that the General Assembly has enacted. The overarching policy reason, I would say, is the protection of children who might not be in their best interest to be bought and sold.
And I think, Senator, to add to that, I think the premise of your statement is predicated upon the assumption that you participated as you should. What our role is to focus on folks who would not participate as they should. So it is the protection of children when entities would not follow the law that you've enacted.
Okay, thank you very much. And we are going to move on. We have a number of things still on the agenda. We've got a few private adoption attorneys who want to speak. We're going to start with Justin Hester. So
Can everyone hear me?
Yep.
Okay. Well, first of all, thank you all so much. Chairwoman Kirkpatrick, thank you for doing this on, during summer vacation. We appreciate the opportunity to talk about some of these issues. And I will tell you at the offset, please forgive my voice. I caught a summer cold from my 15-year-old a couple of weeks ago, and my voice just hasn't caught up. So I know I sound a lot worse than I feel. My name's Justin Hester. I am a practicing attorney here in Georgia in Norcross. Graduated from the University of Georgia, undergrad and law school. Started practicing in 2000, so this is my quarter century mark. I was fortunate to go into practice with my father, Jerry Hester, who fell into adoption almost 50 years ago, trying to help a friend, a couple friend of my parents that were having trouble having children. And so he developed a specialty over those years. And a lot of the attorneys that are here today, I've met through him. Jim Outman, who is the principal author of our adoption code in every rewrite since, is our other law partner. Between the three of us, I think we're now at about 125 years of adoption law experience. My practice is primarily adoption. I've been working in interstate adoption my entire career. That's probably the largest portion of my practice. I do some plenty of in-state adoptions as well, and wanted to kind of I know we have a lot on this agenda, so I really will try to be brief. And if you guys want to tell me to hurry up, please do. I wanted to start by explaining that there is a big difference, and some of the questions I think indicate that we mix and match a little bit sometimes between private adoptions and foster care or state adoptions. The ICPC process is very different when we're talking about a child that's been placed for adoption in a private setting, a non-DFACS, non-state setting. The only involvement of DHS in those adoptions is the ICPC process. So when we talk about a child that is waiting 180 days or an 180-day window to utilize an ICPC approval, that's foster care. When we talk about the sending state approving and then the receiving state then ordering a home study, again, that's foster care. In a private setting, it is very, very time sensitive because you have usually a couple and adoptive parents that are going to travel to Georgia, or a Georgia couple traveling to another state for the birth of a child, typically, or at least, or it can be an older child. That's a little rarer, honestly. The way it works is that people don't voluntarily place older children very often. Those usually turn into foster care placements, but birth mothers do place newborns. They do make adoption plans when they're pregnant. And so most of these cases involve people traveling to the sending state and then waiting for approval from the sending state and the receiving state. When they file their application for approval, they do have they need to have, or before they can apply at least, a completed home study, which is, I believe someone else said, these are lengthy documents, 75, 80-page documents. It is a up, down, and sideways look at prospective adoptive parents that includes a ton of personal information, a criminal histories, both FBI and their local criminal history. Here in Georgia, that'd be a GBI check. 911 call checks, child abuse registry checks. They're required to provide tax returns. They're usually photos of their residents. It's a significant look into these prospective adoptive parents, and that has to be completed before we can even submit an ICPC application. I heard in the crowd when someone asked, is there trafficking going on? A bunch of yeses, there is trafficking going on. I don't know if there is or isn't. I have not had any experience with that in my own practice. And I forgot to say this, I'm not tooting my own horn by any means here, but I do, I do feel like I've gained some credibility. I am a founding member of the Georgia Council of Adoption Lawyers, and I was honored in, I think, 2014 as a Congressional Angel in Adoption in DC. So I do believe that, I hope at least, that my colleagues would attest to, kind of the high level and high level of practice and standards that I try to adhere to in these adoption placements. That said, I've never dealt with anything where I've had any concern for trafficking in a private adoption with a home-studied couple. I just don't see how someone that goes through that process, if you've adopted, you know what I'm talking about, goes through the home study process, would be willing to do that and then traffic a child, because that's all on record. Their whole life is in that home study. So that's just my 2 cents on the trafficking issue. Obviously we're all against that, and Georgia has a problem with it. And, for goodness sakes, if we can be of any assistance with anything going on like that in the adoption world, please let us know. We would love to help. And there are bad actors. We've all dealt with them. There are people that cut corners. There are people that that provide payments that are not that are over and above what would be considered reasonable living expenses. Everyone has seen it, and it does go on. There's no question. We want to try and prevent that as much as possible. That said, every adoption is going to be reviewed by a Superior Court judge in Georgia or an equivalent judge in the adopting parent's state of residence. And it's not like when ICPCs gives approval for that couple to travel back home and they're going to be finalizing in their home state, that ICPC goes away or doesn't have any idea of what's going to happen with the child. There are 2 things that book in that process. One is called the 100A, which is call it the cover page of the ICPC application. It's a 1-page. It was the one that we mentioned, or someone mentioned, was blank by accident. Has a lot of information. It's the top of an ICP, an 80, 100-page ICPC application. When the adoption is completed, and there are post-placement visits that have to happen after the placement and during the adoption process. Once the adoption is completed in the other state, if they're finalizing in that other state, ICPC gets a 100B, which is the closing out document that indicates that it has been finalized. And so whether we trust them or not, these cases do have significant judicial reviews. ICPC was created to make sure that people could get to the point that they are in front of a judge and that what they are presenting to that judge is compliant with law. ICPC doesn't have any enforcement authority. But what we started seeing in 2023, 2023, in my opinion, was a weaponization of ICPC. The problems that we've experienced, I'll be very brief. Moving the goalpost. We all have had ICPC applications submitted and pending, and then been told the checklist has changed. And so there are additional requirements that are not in your application. Well, okay, but we did what we were asked to do based on the checklist that we had at the time. I had a case where I was told that we asked, can we see the new checklist? And it wasn't ready yet. So it was another week before we even got a new checklist indicating what we didn't have that we didn't know we didn't have. I know that there's work to make this process more streamlined, and I'm so thankful for that. But there's still problems. I will tell you that just a couple of weeks ago, got an ICPC approval eventually. But one big issue is that we have these requirements, and then there's this open-ended, and if we think of anything else, we can ask you for it. There's not, it's open-ended. So DHS can say, we're going to ask you for this. No, it's not on the checklist. No, it's not required. But in my case, the home study couples do have criminal clearances, shows their complete criminal history. This couple, the husband had some traffic violations from 14 years ago. One was a expired license, expired tag. That led to a license suspension. I was asked to provide certified copies of those criminal records from 14 years ago. That's so far outside the realm of what ICPC is designed to do, and it delays these people from getting home with a newborn. So moving the goalpost is frankly, it continues to happen. I'll tell you guys. Let's see, the checklist when Georgia is the sending state has been revised 5 times. I'll update that to 6 because we heard it's just been revised again. That was October 2023, January 24, May 24, July 24, October 24, and it sounds like Monday. Let's see, when Georgia is a receiving state in private and independent adoptions, it's been revised 4 times, probably 5 now. When Georgia is the receiving state in agency adoptions, it's been revised 4 times in that time span. And I hope we're at the end of that line. I don't know if we are. Another significant issue is any lack of appeal. This is not subject to any judicial appeal, administrative appeal. The buck stops with DHS. And so if there, again, during kind of the really 24, when things were developing so quickly and we were really experiencing these delays that went on for months, honestly, we didn't know what to do. We didn't know how to we had situations where either there were denials and our packet was returned, or they said, we've identified a flaw, we can't process this. In one of those cases, again, there was a placement made in a private adoption by a birth mother to a out-of-state adopting parents. That application was refused to be reviewed. The birth mother, unfortunately, had suffered and for years had suffered from significant addiction issues. She died. The birth mother died. So there's no way to go back and fix anything or to make this adoption happen with ICPC approval. What do you tell that couple? ICPC will never approve. We have no way of going back and redoing anything because your birth mother unfortunately passed away. How do we handle that? This couple did nothing wrong. In fact, they, were volunteering to adopt a medically at-risk child because of these issues that the birth mother had. Georgia wants those children to be adopted by good families that are willing to undertake the risks that go along with, maybe a severely drug-exposed child. We had to figure out a way around that, and that was to go to the couple's state and get a court order from a judge in their state allowing the adoption to proceed. We've had to go to a number of states and have ICPC approval from the receiving state, despite Georgia's failure to approve or denial. This has happened over and over again. The other issue and I'm sure that y'all have heard about this.
Are you getting close?
Yes, I'm almost done. I told, thank you for for letting me know. The last issue is this requirement that we provide the mother's entire medical file. That is expensive. It's time consuming. And we did a survey, heard back from 48 of the 52 ICPC jurisdictions. Georgia is the only state that requires the mother's medical records, the only state. That is, we have a HIPAA release signed so that we can obtain those records. Generally, it's so we can get those records to the adoptive parent so they can provide it to their pediatrician. But I don't see how that's not a violation of HIPAA if I'm providing that to ICPC, let's be honest, DFACS, and DFACS is reviewing it. And in some cases, DFACS is using that information to prosecute these girls. One girl recently was arrested because she used drugs during a pregnancy. That knowledge was obtained through ICPC. So I don't know how chilling effect that could possibly have on adoptions when word gets out that if you place for adoption and you've used drugs, they're going to come and arrest you. No one's going to place for adoption. So anyway, I will, again, I'm not trying to be critical. I'm just speaking from my own experience and my colleagues' experience. We need to fix this. It is, I talked to a adoptive parents 2 days ago from Cobb County. Wonderful couple. They're just getting started in their journey. They talked to 2 agencies out of state. Both agencies told them, we will not work with families from Georgia. We won't work with birth mothers from Georgia right now because of what we're dealing with Georgia ICPC. That we have this packet that we sent you guys. It's got some information, some from families that have been through this. It's Wendy did a great job of kind of tabbing it for everyone, from parents, from agencies, from other attorneys, this is not like we picked and chose the best or the most critical. This is just what we're dealing with. This is a cross section of the experiences that these folks have had, and the black eye that Georgia adoption, at least interstate Georgia adoption, has. The proudest moment of my professional career, Dr. Kirkpatrick, you were integral in it, was the passage of HB 159, our adoption code revision, brought Georgia into the 21st century, made it easier, made it less expensive, made it quicker for people to adopt. What's going on now, I feel like has reversed all of that and made it worse than it was before with interstate adoption. Thank you.
Thank you, Madam Chair. Thank you for the testimony this morning. Just a quick question. I heard you mention the birth mother. What about the father in any of these conversations? And what effort is given to work to ensure that the father's interests and rights are represented equally?
Oh, no, not, and I apologize. Usually that's a bit of a shorthand. In many of these cases, we're talking about a birth mother and a birth father. In some cases, the birth father is not cooperating or unknown or unnamed. And so that he is certainly given due process, but it's not part of ICPC necessarily.
And what is due process? Is that service by publication? What is that due process? Because if you say, well, who's the father? I don't know. You know, but does the father get the opportunity to have any clawback or any clawback provisions to have access to the child if he says, the mother said she didn't know who I am and I can prove that she knew who I was and she put this child up for adoption?
He does. I mean, we have a putative father registry. So 2 people, make a mistake and have a crazy night together, and he's worried that, maybe something's going to happen. Go online and register. He will be protected and receive notice of any adoption placement. By law, a father who's not married to the mother is on notice not only that a conception may happen if he engages in sexual relations with an unmarried woman, but he's also deemed to be on notice that an adoption placement might happen. So if father's identified, yes, he does receive notice of the adoption. He's instructed that he has 30 days to file a petition to legitimate a paternity action. And so that's how he objects to the adoption. Birth fathers do receive significant due process. We're very similar to a number of other states. Our legitimation process is different than most other states, but as far as the notice, and now birth mothers do have a right a constitutional right to not name the birth father. You're right. They say, I don't know who he is, really. But she can say, I know who he is, but I'm choosing not to name him. And then we have to search the putative father registry to see if there's been any registration, if there is required to provide notice. But those are on the again, not ICPC issues, but they are, obviously very, very important issues in the legal process of an adoption, which is a judicial proceeding. Does that answer your question?
In a roundabout way, but no.
Okay.
Thank you, Senator Islam Parks.
Hi, thank you. So you mentioned that you've had to, that this checklist has been revised multiple times, as you mentioned, 4 or 5 times. And did this all start really in 2023, or before that, did the checklist was it always updated? Was this a newer thing in the last couple of years?
The checklist has been the same for years and years. I think that the first one was in late 2023. I can't recall. I mean, there may have been changes over the years to update as I don't recall specifically, but not with any regularity.
Okay, and how long have you been helping with adoptions? How many years?
Since 2000, 25 years.
Okay, so you would have knowledge. And just one clarity. So you said that Georgia is one of the only states, if not only state, that requires the medical record of a mother, and it was just used to arrest a mother that was giving their child up for adoption?
Correct. That's there are no other states that require the mother's full medical record and a certification that it's the full medical record. That can be 1,000 pages. It can cost $1,000.
Okay.
No other states require that. The purpose of the medical record, providing any medical records in ICPC, is to confirm that the child was discharged from the hospital and is healthy enough to travel.
Okay.
And say, yep, there's a child that was born and discharged. So yes, we can prove ICPC. Not to scour through the confidential medical records of the birth mother.
Got it.
Thank you. Ronnie Fishbein?
Can you hear me okay, everybody?
Yeah.
Okay. Good morning, Senators. My name is Ronnie Fishbein, formerly Rhonda Fishbein. To tell you a little bit about my background, I graduated law school, Cardozo School of Law in New York City in 1982. Moved over here and clerked for a federal judge, and after that, worked at 2 of the large law firms here in the Atlanta area. We adopted our oldest child, and then in 1988, I formed my own law practice, which is devoted just about exclusively to adoption law. So I have been practicing in this area for a very long time. I'm a fellow with the Georgia Council of Adoption Lawyers. Many of my colleagues are here. I also was the first Georgia attorney admitted into the Academy of Adoption and Assisted Reproduction Attorneys. Just to make you aware that both of those organizations have its own code of ethics. So most of us that do interstate adoptions are bound by code of ethics, which includes offering independent representation to a biological mother. In fact, that is included in our acknowledgement of the surrender. So there is absolutely a requirement, even if it's not in the statute, that we offer that independent representation. Although much of the previous testimony involved children in state custody, and relative placements or residential placements, I'm here to address private agency and independent adoptions. And for those of you who don't practice in adoption law, when I use the word independent adoption, it's when a birth mother is transferring parental rights directly to adoptive parents, not to a licensed agency. So there's not going to be any agency holding legal custody. I formed Adoption Planning, Inc., a Georgia licensed child placing agency, in January of 1990. My agency was granted a contract with the former adoption unit of the Department of Human Resources, that's what it was called back then, in August of 1999 to act as the Georgia ICPC Cotton Pact Administrator. That was an incredible honor, and my agency had that responsibility all the way through 2008. Our role was to review packets to determine if adoptive parents could either leave Georgia to return home or leave the state in which their child was born to return home to Georgia. Although 2008 is 17 years ago, it is important to note that the Georgia ICPC office continued to operate the same way and had basically the same requirements all the way up to November of 2023. So my agency may not have been involved in any role in administering the ICPC, but there was consistency. We also had uniformity with the other states. There was never a question, about changes that we were not made aware of. Without notice, everything changed in November. 2023. The American Public Human Services Association, which includes the Association of Administrators of the ICPC, states that the ICPC establishes uniform legal and administrative procedures which govern the interstate placement of children and is statutory and a binding contract between member jurisdictions in all 52 member jurisdictions. That word uniformity you heard from our first presenter. It's supposed to be a compact that is uniform among all the states. Today, the Interstate Compact Office and all other states have continued to require the same ICPC requirements as listed on Regulation 12 of the AAICPC. You've heard reference to Regulation 12. The Georgia office, however, does not rely on Regulation 12 and requires items not required by other states. So the checklists that have been referenced and changed and referenced again contains many additional items not required in other states and in fact not even on the Regulation 12. In fact, there is no consistency in what is required by our Georgia office because we have received so many versions of this checklist. Today, our Georgia ICPC office can take more than 1 week for an initial review. Our understanding is that the packets undergo a second review by someone in leadership. We have never been told who leadership is, and it's only today that we're finding out who may be doing that second review. We never knew who was then doing that second level of review. Attorneys and agencies then receive a list of additional requirements and questions that frequently are not even on the most recent checklist. There are delays of up to 6 to 8 weeks or longer, and there are instances where adoption packets never receive approval. My colleagues and I do not understand the changes and have never been provided clear explanations of the reasons for these requests and scrutiny. We do not understand what rationale exists for the current review process. We have heard rumors of sex trafficking. If you talk to any of my colleagues here from Georgia Council of Adoption Lawyers, we're in purple, you'll spot us. None of us have any knowledge of sex trafficking with the adoptions that we've been involved with. We would love to know what the rationale is for all these stringent new requirements and for the delays. There's also inconsistency in how the checklist is applied. For an example, with an agency placement, that is when birth mother, biological mother transfers rights to an agency, the Interstate Compact Office will grant provisional approval as long as that agency shows that they've requested the medical records of the biological mother and of the infant with the certification. With independent adoptions, where there's not an agency holding legal custody, we are not granted provisional approval. And with some hospitals, it can take months to get those medical records. It's outsourced. It takes a very long time. There's really very little we can do to expedite acceptance of few cooperative hospitals. When we're asked why an agency can get this approval, I was so excited when I first heard it. I was told, well, this is decided on a case-by-case basis. You heard that earlier, that it's some things are decided case by case. Interstate Compact should not review packets and decide case by case what's required. There should not be priority for one group of packets that are being reviewed, one group of placements, and not given the same respect for another group of placements. In addition, we're now told, as of, I think it was right after November of 2023, that with an agency on the 100A, with Justin just explained, is the cover sheet that goes on top of that whole packet. The birth mother is signing that if it is an independent adoption. But on the top, it says who's responsible for planning for this child, who's financially responsible. In an agency placement, clearly the agency goes there. They're holding legal custody. They helped with this match. They go on there, they're signing that 100A. We now are told that we, as attorneys who did not do the placement, we do not hold legal custody. We're not an entity like in Florida where we can, place children. We have to sign the top of the 100A that says we are responsible for planning for this child. We are responsible financially for the child, and we need to sign the bottom next to the birth mother's name. Although we disagree that that is any kind of reasonable requirement, it goes way beyond what we should have to do as attorneys, because we're not responsible for planning. We did not want to hold up the approval of our packets. If our families are staying here, they need approval. So we go along and we sign that, but again, it's unreasonable. In addition, private information from ICPC packet has been shared with other agencies or departments about the adoptive parents and biological mothers. Recently, the DFACS Special Victims Unit contacted adoptive parents, I was involved in that adoption, who are waiting for approval to return home and insisted on visiting them and the child in their temporary home. There was never any information that raised concerns about the stability of the adoptive parents. They had an approved home study with all those clearances, or the safety of the baby. This information had to come from ICPC. How else would they know the phone number to call the adoptive parents? This was terrifying for the family. I was able to intervene, and the baby remained with the adoptive family in that case, but that's not always the case, as you're going to hear from my colleagues. As practicing attorneys, these changes have been frustrating for us as professionals because we are not able to provide the same representation to adoptive parents or biological mothers in Georgia due to these unacceptable delays. Georgia is no longer viewed as an adoption-friendly state. That goes against everything that our leadership here, our governor, everything about the changes in the adoption code were supposed to accomplish. Attorneys and agencies outside of Georgia are refusing to assist Georgia biological mothers or Georgia adoptive parents in their adoption process. This hurts Georgia residents who are seeking to adopt a child and Georgia biological parents who are seeking to identify adoptive families. So they're being told, as Justin said, sorry, we cannot work with you because of Georgia Interstate Compact. And we hear that more and more. I mean, families tell us that, biological mothers tell us that, the agencies and attorneys in another state. I've had other ICPC offices complain that even if they make a request to say, well, what's holding this up? All they're told is it is under review. So even interstate office to interstate office, they're not given real information. For those of you who are not familiar with adoption, the purpose of the ICPC is to provide oversight and monitor interstate placements of children who are crossing state lines to ensure they end in successful adoptions. This function is performed efficiently, professionally, and quickly by all the states except Georgia. Thank you.
Back again, Madam Chair. Is there an agency or an entity that ensures the other state's compliance with the ICPC? Is there a body that reviews to ensure that every other state is complying with all the rules? Or if it's just, we go along to get along, if you do it, I accept it, that's okay, as long as we both agree?
Well, there is that office up in Washington, D.C., but when we went to that office, which is the AAICPC office, shortly after November, when all this kind of started, we were told they don't get involved with individual state ICPC office problems. But all the states, as well as Washington, D.C. and U.S. Virgin Islands, they all have those ICPC offices, and they're using Regulation 12. So we have some authority coming from.
Thank you, Miss. My question, is there someone who refused to ensure that other states are compliant with the ICPC, not just because they say it's easy, but are they reviewing the requirements that are set out and determining if they're following the rules?
Well, if we are the receiving state and another state does not have the required documents in the packet, for example, if there's no home study, or you don't have the required legal consent, whether it's a Georgia surrender or an out-of-state, our Georgia office is going to require that. So that, it's mutually working together to make sure that all the requirements are satisfied. So there is no one individual. I hope I'm answering your question.
We're missing it. What I'm saying is, so if Georgia is saying, if you're saying Georgia is difficult and other states are easier, is that because they may or may not be following all of the rules and what that compact requires?
They're following Regulation 12. Okay? Regulation 12 is what lists the requirements for private agency and independent adoptions. They are not just going and saying, oh, here's a packet, I'm just going to sign off on this. So they are following the requirements that existed before November of 2023. I mean, so if Georgia gets a packet where something's missing from Regulation 12, they're going to request that. So they're not just able to just sign off on it, and they're following the requirements that are in that regulation promulgated by AAICPC. I hope that.
Senator Islam Parks.
Hi. So I'm just trying to understand all the entities that are involved in Georgia's adoption process. What role does the DFAC Special Victims Unit play in Georgia adoptions?
We did not know. I mean, it came as a complete surprise when I got a call and this adoptive family got a call from the SVU saying, we've been contacted and we have to go out there. I have never had the involvement of the Special Victims Unit in any other adoption. I don't think any of my colleagues have either.
Okay, thank you.
Okay, thank you very much. Sherry Ann Hicks. And for the committee, we've still got a lot more people to be heard. So if you need to take a break, take a break. But if you guys could just be as concise as you can testify, that would be really great. Thank you.
Hi, good afternoon. Thank you so much for having us. We are honored to be here. I'm Sherry Ann Hicks. I'm an adoption attorney. I spoke to you, I think, last year in Columbus. As you know, I am the immediate past president of the Academy of Adoption and Assisted Reproduction Attorneys, which is a network of about 450 attorneys that are nationwide, and it's a great source of interstate work. And so I have a lot of familiarity with interstate adoptions and how it was and how it is now. I come to you as a professional that's been in this field for 30 years, and until November of 2023, virtually did not have any problems with the ICPC office at all. As you have heard today, there are problems now. Those problems are affecting Georgia families. Those problems are affecting Georgia birth parents, and we need your help because we need to solve this problem. This gentleman just asked, is there something that is somebody that can say you're asking for more? There's not. And that's what we're facing here in Georgia right now. Typically, we follow Regulation 12. The checklists are supposed to model Regulation 12. And now they're not modeling Regulation 12. They're far exceeding that. You may say, well, that's a good thing, right? We're asking for more. We are offering more protection. Well, it's not, because at the onset, we don't know what's going to be required. And we've got families who are spending thousands of dollars to stay in hotels and Airbnbs with newborn babies. In addition to that, the scrutiny that is coming upon our packets when we take them to ICPC and submit them to ICPC is is excessive. Your signature is not the same on the 30th page that you signed as it was on the second page. That's because her hand's tired. So what we want to point out is we need this fixed. We need to know what the rules are. You hear incomplete packets. That's not the issue. We can't give you a complete packet because we don't know what you want in your packet. And I'm the one who submitted the blank form. I'll out myself. I didn't mean to. I broke my foot. I have a new paralegal. The 100A that we submitted in my packet last week was blank. I'm horrified. But do you know what? It took a week for me to find that out. A week. So Josie and I wanted to share this just from another level because Josie and I had a horrific case in Cherokee County. I'm going to let Josie tell you how it started, and I'm going to tell you how it ended so you can see how this is impacting families and children.
And this is about the Vietnamese mother and the family from Florida. And I will also add that this is affecting Georgia babies as well as birth mothers and families. Christina Campbell is a colleague of mine, and she was retained by a Florida family to help them with an independent private adoption of a baby born in Georgia. She had not done a lot of ICPC work. She asked me to assist because I've been practicing 29 years. I've done hundreds of ICPC packages, and it was a very interesting case, and I'm always up for a challenge. This was a case where the birth mother was an undocumented Vietnamese citizen living in Georgia. This birth mother had given birth at home, so there was no hospital record of the birth. This birth mother needed independent legal representation, which I provided. I was her attorney. I told Christina and her family that, normally ICPC approval takes, a week to 10 days at the outside, but this case was special, so we were going to have to do some extra things. So because the baby was born at home, I first wanted to establish the identity of the mother. So I required copies of her passport, copies of her entry documents. I needed to establish that she was the mother. So I required DNA testing to prove that this mother was the baby. I need to make sure that she understood the surrenders and the impact of the surrenders. So I had the surrenders translated from English into Vietnamese, and I had a Vietnamese interpreter present when I met with her to take surrenders. The process took about 2 hours, and we went through the whole every document, word by word, line by line, made sure she understood the legal force and effect of what she was doing, that she had selected this couple, and she selected a couple that shared her faith of the Catholic religion and who also shared her ethnicity, and that the adoptive mother was Vietnamese as well, and they could communicate freely. So I did all these things because the baby had been born at home. I did not have a discharge summary, and I did not have a proof of birth. So I went to Vital Records and submitted the affidavit and the application to get a birth certificate for this child. I had the family take the child to a doctor to get a well baby check to prove that the baby was healthy and able to travel. I filed the packet. I think we started this process on November 2nd. It took, a couple of weeks. I filed the packet with Georgia ICPC on November 13th of 2023. I was informed on November 15th that it was approved and had been sent on to Georgia, which was typical for the time. Florida, sent to Florida. Thank you. But after I was informed that it had been approved and forwarded, I got about 12 to 15 emails asking for new, different, additional information about this placement. And I complied to the best of my ability, but I could not provide hospital discharge records for a child that was born at home. So I responded within hours of every request. Finally, on November 22nd, which was the Wednesday before Thanksgiving, I got a request for the location, the local address for the family, the adoptive family in Georgia. And I provided that address. And within hours, 2 policemen and 2 defects workers were at that home with no notice to me or to the adoptive family, no explanation to me or the adoptive family or the birth mother, and they removed the child from the home where he had been with his family for 2 weeks. And that, I'll let Sherry Ann take over. from
So
there.
when I got brought in the case, the child had been declared dependent by the Cherokee County Juvenile Court, even though there was no dependency because the mother had made an adoption plan for her child. She had not created any act that left that child without proper parental care or control. And the adoptive parents, my clients, surely hadn't done anything wrong. They had no idea why this child was taken. They were home study approved by Catholic Charities. Like Josie said, they shared the same faith, shared the same culture, and they were committed to this child. This child was removed from their care because of a belief through ICPC that there was trafficking going on because there was an undocumented birth mother and a baby born at home. It took my clients 1 week short of a year to get this baby into their care. This child stayed in foster care at the expense of Georgia taxpayers. In that case, there was an excessive and unwarranted intervention by Georgia ICPC that impacted the first year of this child's life. They assumed she was being trafficked. They made up their version of the facts of this case based on the information that they were seeing in an ICPC packet. They didn't pick up a phone and call and ask for details. They started an investigation. And that investigation was ultimately non-productive. It produced no evidence whatsoever. And ultimately, the case was dismissed in the juvenile court of Cherokee County, and that child got to be with his parents. But this is a year. This is a family that had to travel 5 times to Georgia for dependency hearings. This is a family that thought they were taking their baby home any second, that now has a baby in foster care. Baby had 5 placements in foster care. Luckily, the foster mother was warm and lovely and was willing to be involved with this family. But what a tragedy for this family. Other cases like this, we know that these families are traumatized by this experience. We need uniformity in this space. That's what we need. We need a checklist and we need guidelines that when we submit this packet, we know this packet is complete. We'll follow your rules. We just need to know what they are. It's that simple. So my ask to you is, if we are going to allow DHS to make these checklists, could we have a seat at the table? I know we are not government employees, but could we be a part of the conversation to help them sometimes understand how things do work in private independent adoptions? Yes, this was a happenstance adoption. She went to her church, the birth mother went to her church, her Catholic church, because the priest at the Catholic church spoke Vietnamese. That's where she went for help. And when she got there, they helped her. But that didn't seem normal to somebody at DHS. And so it all fell apart. So we need to know what the rules are. And that's our ask for today. So we appreciate you. We appreciate DHS. I have had a wonderful relationship with Regina and the commissioner and with all of the people who work at DHS, but it's just extremely frustrating. And it's not just incomplete packets. We just don't know what to put in the packets.
Thank you, Senator Mallon.
Thank you, Madam Chair. I think you probably should have led with how the adoptive parents met the mother, because I thought it was trafficking when I heard it,
Yeah.
right? So I think if there's a way to explain how that happens on the front end, that would make a lot more sense, because I said, man, did she come through the Port of Savannah? Because how would she have gotten here and got to Cherokee County to have a child? And then how would they find that this child existed? So I think all those things are important in a case-by-case basis. And I just share the sentiment of, when you're reading the paper, it looks exactly like that. And I would not want to be the person to approve something and this woman had been trafficked and it fall back on me, the individual. And I think that may be something we can look at, because after the adoption, you're clear, free and clear. It's gone, it's done, right?
Yes, and it's a great point. We do that already, though. See, that information even though I didn't lead with it in my testimony, which I should have, that is in our cover letter. So that was information that Ms. Redwine shared with the Georgia ICPC office, just so they would know how that adoption came to be, because she knew that it would look like trafficking if she just submitted a bunch of paperwork without an explanation. So she did give a very detailed explanation. But what happened was
And a DNA test.
it still led to an investigation that kept a child in care for a year.
No, I completely understand. Did the priest sign anything that was included in that to attest that that conversation happened?
There were witnesses that were identified that had the conversation with her as well, and they were identified.
Thank you very much.
Thank you.
We're going to shift gears a little bit, and we've got a couple people who want to, from the standpoint of private adoption agencies and placement issues. And then we have a number of people signed up to testify after that. So if any of the committee members need to go, just, do what you got to do, but we're going to be here a while longer. Carrie Nellis.
Thank you so much. I know y'all are very tired and probably exhausted from hearing from attorneys, so I am sorry to be yet another attorney to hear from. I am Carrie Murray Nellis. I am honored to be here before you today. I have a couple of different hats that I wear. I am an adoption attorney. I've been practicing since 2005, a graduate from Mercer Law University. And I also do run an adoption agency. I have Abiding Love Adoption Agency. We are licensed in Georgia. We are also licensed in Florida and licensed in South Carolina. Georgia is our home state. That is where I started. That is where my practice started. I have the privilege of also running up and down I-16, as the senator mentioned earlier, because I live in St. Simons and Brunswick. And so that is one of the reasons that we are licensed in all of those three states. The reason I started Abiding Love, I want you to understand, because I think it is very important for the testimony that y'all have heard today. I started Abiding Love because as an adoption attorney, I would get phone calls from out-of-state agencies. I would get a phone call and say, hey, can you go to the hospital in 2 hours and meet with a mom, have her sign these surrenders, and then I need you to also do the ICPC and terminate parental rights, all of that. And I'm stand or sit before you and say that they paid very good money for that. They paid me $5,000 to walk in there, to have her sign those documents, and to process an ICPC. It was great money, just being honest. And I had law school loans to pay back. So I would walk into the hospital room, and over, I was the first person she had ever seen in person regarding her adoption. I hope that seeps into your hearts. This woman had already given birth. There's an adoptive parent there at the hospital, and the adoptive parents are freaked out. They don't know what their role is. They don't know if she's going to sign. They don't know anything. They have nobody there advocating for her. There's no agency representative, no one boots on the ground there. Instead, there's this attorney who just walks in and says, I have documents for you to sign. One of the things that the other senator asked was, what are requirements for adoption attorneys? What are we supposed to be, what is the oversight, correct? There is an attorney affidavit, a petitioner attorney affidavit that I would have to sign. And in that affidavit, it states very clearly that as the attorney who took the surrenders, I am on my bar license under oath, because again, whenever you notarize something, you are technically under oath, saying that she was of free, sound mind. She understood exactly what she was doing. She had looked at all other resources in order to see if there are other options that she had before you. I sit here today because I couldn't sign that document for a lot of women, because she had never been told about pregnancy centers that were in her community that could help her to parent. The majority reason that the women were placing was for financial reasons. No one had told them about diapers, about WIC, about all of the different programs that this great state has put into place in order to make happen. No one told them about community resources that would help them to be able to parent. And I felt my responsibility as an attorney, which I take very seriously, is to actually make sure she understood all of that. And many of them said, I don't know if I want to do this. And I said, then you don't need to do it. Don't sign. I would call the adoption agency when I walked out and I would say, she doesn't want to sign. And I said, or I would say, she does want to sign, but I don't think she really understands what she's doing. And I, as the attorney, don't feel comfortable. And you know what they would tell me? They would tell me, I don't care. I'll find an attorney that will. And guess what? They did, over and over. And so in 2016, I did something that I never wanted to do. I had to start an adoption agency because as an attorney, I have no checks and balances. The only time my file is looked at is if there's a bar complaint or the judge at the end. And let me make it very clear. The judge is at the end when he reviews this file. He's looking at it in 3-6 months after this child is already bonded with that family. But as an agency, I get audited every year. I don't know when the state of Georgia is going to come. In fact, I know y'all are tired, but a little bit of humor, because it's the only way I know to live. My former auditor in our area, her name was Siri, and it was a running joke that I would say, hey, Siri, when is Siri coming? She did not appreciate that. She has since retired. But I don't know. I've been in court at times when she showed up and she would say, Carrie, you've got 30 minutes. I had the flu once. And she said, you've got 30 minutes. And I'm like, okay. But she looks through every one of my files. She looks through our finances. She looks through our taxes. She looks through our accounts. She looks through all of the receipts for every birth mother expense. And she looks through all of our employee records. Is it a lot of work? Absolutely. As an attorney who is not, and I'll just confess here, I'm not a huge government girl, but I do appreciate the oversight that there is, the checks and balances. That makes me a better practitioner. That makes me accountable to my clients, to the moms that I serve, and to the children that we place. I have heard the testimony from my colleagues, and I guess I have a very different experience. Because I'm on the front lines of Abiding Love. I'm the one, when you call and you text, you get me. You call, you get me. Every day except for Shabbat. So I'm on the front lines. I get the phone calls. And you know what my phone calls are? Hey, how much will you give me if I make an adoption plan? That's one of the first questions I get. What am I going to get out of this? Will I get a check or will it be cash? And how much is it going to be? And so I disagree with my colleagues that there is not trafficking. I have seen sex trafficking. In fact, I created a separate organization at one point, Faithful Love, that was for helping with sex trafficking because so many of the women I was serving as birth mothers had been caught up in sex trafficking. But what we're talking about here is child trafficking. And sometimes, I'm going to be honest, it is by the mothers. Not all. And I'm not here to villainize, please know my heart, but because the industry, the adoption industry has perpetuated this. They have paid her directly. They have paid her, they've wired money. They have sent her gift cards. They have given her cash. They have given her checks. And so this to me is a huge problem. And I stand here as a proud Georgian and I say, I am very proud of our state. I'm proud that we actually have stopped rubber stamping ICPCs. Yes, there was a change. There's been a significant change. There's a change in the checklist that we have. It is extensive, but it has made me as an attorney, it has made me as an executive director, it has made me as a supervisor of my case managers and advocates a better practitioner because I am dotting my T's, or dotting my I's and I'm crossing my T's. I am making sure that on my affidavit that I have to submit to ICPC has everything right, that it's actually added up correctly. Because believe it or not, the software I had it incorrectly added, which was a problem, and we had to address that. But these are the details, but I'm sorry, it's worth it. She is worth it. The birth mother is worth it. The child is worth it. And the adoptive parents that we work with, I have never had one of them complain that it is now taking them 2 to 3 weeks to pass through ICPC, because as I have explained to them, and I explained to them at the beginning, when they match with my mom in Georgia, and I'm like, look, I just want to let you know, Georgia ICPC crosses their T's and they dot their I's. And so I want to let you know it's going to be a longer process because they want to make sure that we at Abiding Love are doing everything that you want us to do, that you are entrusting us. I agree with what was said regarding the adoptive parents. They are home study ready. They have no clue what is going on in the underbelly of adoption. No clue. They are trusting their adoption professionals. They're trusting adoption attorneys, and everybody's turning a blind eye to it and saying, oh no, it's okay, because it's been okay for so long. And I'm sorry if it's requiring us as professionals more work. And I am sorry that if it's requiring more hours. My family can say that I have spent more hours at the office since this has gone on. I have been more detailed with my staff, even with the social medical. You know, I mean, a social medical, which is a document that is about 14 pages long, where the birth mother or the expectant mother at the time lists all of any medical issues regarding her history. It is an important document because she might not have an open adoption, or she might want an open adoption and run away. So this is an important document that she has that for this child. So this child has, and there's sometimes blanks. They might say, yes, I have a history in my family of cystic fibrosis, but it doesn't say on there who. And you know what? ICPC has called me out on it and said, Carrie, she needs to fill out who in her family had cystic fibrosis. And you know what? They're right. They're right. And they called me out and said, you know what, Carrie, where is, who's getting money here and who's getting money there? And I said, you're right. Let's write it out. Let's make sure it's very clear. And I'm going to sign under oath or notary that no entities were given money. No entities were involved in this illegally, and making it very clear, everybody, as I think it was Senator Parks, you stated there's a lot of players. There are a lot of players involved in the adoption world. And you are right. And so unfortunately, we've got to make sure, and we have ICPC as that first line of defense to make sure that everybody is playing according to Georgia law, following Georgia regulations, so that we can protect birth mothers, expectant mothers, and children. And I'm also going to say to protect adoptive parents. Because like I said, most of them don't know any of this is going on at all. When I sat there and looked at adoptive parents in these hospitals, when I got called in, and they would, I don't know what's going on. I don't know. Is this right? Is everything okay? That's horrible. They deserve to have someone boots on the ground at the hospital walking them through this. That mom deserved to have somebody holding her hand when she gave birth by herself and actually helping her home, helping to her to her hotel. That is common decency. And what has happened is that these out-of-state agencies have found backdoor ways of making it legal by turning an agency adoption into a private entity adoption. And I was part of it. And I looked at a woman once in Warner Robins who was crying, and it was just like a road to Emmaus moment for me. And she said, I didn't know I had other options. And they told me I had to sign. And I said, no, ma'am, you don't. And let me get you connected with a pregnancy center in your area, and you have options. This is what's going on in our state. I'm sorry I have a different experience than my colleagues, but as an adoption attorney, and now as the owner and runner of executive director of an adoption agency, I have a different experience. I want to say that, yes, there is a term, a viewpoint of Georgia that we are not a quote unquote adoption friendly state. I'm proud of that. I'm proud that what that means is it's not an easy way to get things under the table. I'm proud that we're actually following our laws. We are an adoption-friendly state to birth mothers, and we are an adoption-friendly state to adoptees, and we are an adoption-friendly state to adoptive parents who are doing things the right way. And I'm darn proud of it. I heard something at the Adoption CLE in 2024 that was in November, and I highly recommend that all of y'all watch it. It's very enlightening. And one of the things that was said by my colleagues, and it broke my heart, it said that the rumor, that the viewpoint of the Georgia for the United States is that out-of-state agencies is closed in business to Georgia. Praise Jesus. Yay. We should be. I cannot go to Alabama and work on an adoption. I can't work with a mother in birth in Alabama. You know why? Because it's illegal. I'm not licensed there. I can't work with a mother in Tennessee. I have them call me all the time because, you know, Tennessee is right there. And I say, I'm so sorry. I am not licensed in Tennessee, but let me find you an agency that can. That's what we agencies should be doing. We should be working together instead of backdooring it, because she deserves to have someone on boots on the ground working with her throughout her pregnancy, not treating her like a commodity. And as an attorney, I stand before you and say that is what my experience was. That is what my continued experience was. I also would like to say,
Can you wrap up pretty soon?
I will, which is hard for an attorney.
We've seen that.
I see. You should see our dinner table, Senator Kirkpatrick. We've got 2 attorneys, so. The argument is that the courts are the proper place. Again, the courts really, they have the important role. I get it. I'm with you on that. But they are not seeing these cases until 3 to 6 months later. And with all due respect to the judges, they don't know adoption law. They're entrusting, there's usually a relationship between the adoption attorney and the judge, and they are believing what we say. I have begged my judges, look through my documents. In fact, I've had some recently said, hey, I've seen that your financial affidavit is like 6 pages long versus the 1 page before, because all I would do is just kind of add up, you know, the categories of housing, clothing, food, that kind of thing. But now, because ICPC requires it, I list out every expenditure. And I actually add up all of that, and I have the birth mother sign that this is what she received and that it was not done. I never gave her cash. I never gave her that. And the actual attorneys were, the judges were like, this is great. And I said, yes, because ICPC is actually making me a better practitioner for you, so that you know when you looked at it, and this has got a stamp of approval from ICPC, that it means something. Case in point regarding one other thing, and I promise you I am wrapping up. You asked about other states. I had an adoption in September of last year. It was a Georgia family, a Florida family, Georgia mom. Georgia ICPC took 2 weeks to go through the ICPC. They asked for things, I gave it to them. They sent the ICPC, because I get a notice through NICE, they sent the ICPC to Florida on a Friday, 10:37 a.m. At 10:55 a.m., I got an email from Florida saying they approved it. Florida never read that. Florida never looked at my ICPC packet, and they didn't look at anything that Georgia sent. They just rubber stamped it and they approved it. And I'm sitting here saying, as a Georgia attorney, as a Georgia resident, as a Georgia adoption agency, I am proud that we're not rubber stamping. Is it more work? Absolutely. But to me, she's worth it.
Okay, we've got a couple questions. Senator Estevez, you were first.
Yeah. Thank you so much for your testimony. I'm curious about agencies and the fees that they charge.
Mhm.
And I know nothing about this. So
Let's do
if
it.
you can educate me on that.
Yeah.
How does the agency charge fees, and then answer that first?
First of all of our fees are approved by DHS every year during our audit. When you get licensed, that is part of the licensing packet application. And then every year they approve that and how the fees are set out and what they're all for. Adoption is expensive when it is done the right way. The adoptions that I was telling you about, where I got paid $5,000 and nobody was there, do you want to know what they were charging? $65,000. And mom had never seen anybody until me. I have a problem with that. For us at Abiding Love, we have a general agency fee, and it is around $40,000. I will go on the record to say that. But it includes, it's not just, most agencies just include the termination of parental rights. And then you have to hire another attorney to finalize. We include every one of our moms has a separate counsel. They are not given the option. They have their own attorney. If they don't have one, we will give them a list and they can choose from. And we pay for that. So in our fees is that. the termination of parental rights, and the finalization of the adoption. And then also all of the casework. But for us, we're at every doctor's appointment. We are there the entire time she's at the hospital. We sleep there because many times most women don't have anybody there to help them to the bathroom. We're there, her advocate. Our moms, they get their own attorney, they get their own advocate, someone that's at the doctor's appointments. They get their own mentor as well, someone who was placed for adoption before. I have walked alongside women for 20 years, but I have never been in her shoes. She deserves to speak to someone who has. The other thing that is unique is she gets formal counseling outside of the agency. I don't believe that it's ethical within the agency because I don't want anybody to say that we're trying to coerce her or counsel her to make an adoption plan. The reason that it's very expensive, insurance. We have never been cited. We have never been sued. And this is a hot topic for me because June is when I renew our insurance. Would you like to know what we have to pay every year for our premium? $70,000. Yeah.
I'm sure that's continued to go up.
Yeah. And so that is one of the reasons, because when adoption's done right, it's a lot of time. But for us, and just to give you our numbers, we served 433 women last year in the 3 states that we're in. We had 16 adoptions. So those fees for those 16 helped us to serve those other women, to help them to be able to parent, to help them to find the resources that they needed in order to parent.
And then when it comes to out-of-state agencies playing in the same, working together, playing the sandbox, does an in-state agency charge the out-of-state agency?
Yes.
How much? How does that work? Like,
Yeah, but it's very frustrating to me because I've had some reach out to me and say, hey, can you be the boots on the ground? But they warrant basically a 70-30 split where they keep 70% of the fee while we're doing all of the hard work, boots on the ground, and they will only pay us 30% of the fee, which won't cover my caseworker or my advocate's time.
So what's typical in that situation?
Yeah, I had one reach out to me earlier this year and they wanted to just pay me $15,000.
And then very last question, what about if you reach out to Florida agency or some other agency out of state? What's that arrangement like?
I can't tell you because I don't work with mothers that are not in another state.
Okay.
So that is an ethics thing for me. I don't believe it is ethical because what sets, I think, Abiding Love apart is I want her to have boots on the ground, someone loving her right where she is, to be walking this with her the whole time. And if I hire someone out of state, I don't know if they're going to follow through with that, and she deserves that care.
Thank you.
Senator Jackson.
Thank you, Madam Chair. What you made the statement that people here think that it should be the judges who make this decision. That's actually not what I've heard today. What I heard from some of these other attorneys is a desire to just simply know where the goalposts are and for those goalposts not to keep moving. So in your experience, have you found yourself having to trip up and do something again and again because the goalposts have changed?
I will say yes, absolutely. But my philosophy of it is, okay, what do you need so you can know that this was done ethically and this was done well? I mean, I submitted an ICPC 2 days ago, and they wanted me to put in the cover letter additional information that's never been asked for. And so I said, okay, and I got it to Ms. Dyer within an hour.
So, but can you talk about the consequences of these types of delays, right? So you've got an adoptive family, presumably staying in a hotel or an Airbnb, who have done all the right things. They've opened their heart to caring for another child. Thank God, right?
Yeah.
So then you submit the application the way that you thought it was correct a month ago. You get feedback. Nope, rules have changed. You get a delay. That family is delayed once more. Like the grandparents don't get to meet this new baby. If there's siblings that are left at home in the home state, they're not being able to meet the baby. Like each time the goalposts change, isn't there a real impact on the families and of the baby that are waiting to be able to go to their home state?
There's always going to be an impact, and I can't deny that there is. But the fact that the making sure that this is a safe placement, this is a good placement, this is a legal placement, to me outweighs that. And the adoptive parents have to walk into this knowing why there is this going on and why, you know, there's the delay. For us, we spend an enormous amount of time putting our ICPC packets together well before mom even gives birth. I'm a little bit type A, Senator Jackson, so there may or may not be a table of contents. There may or may not be everything numbered because while I know Ms. Krim said it's about 100 pages, I respectfully disagree. I think it's more about 500 to 1,000. And I cannot imagine ICPC having to look through this and be like, I don't know where that letter is. So that's why we are very meticulous with that. But it has not been extremely long. What I have heard, the ones that are being extremely long, is when there are red flags or yellow flags or concerns, and that's the issue. But my clients, I can sit there and say, I have not, since all this has happened, I have not had an adoptive parent say to me, this is the most ridiculous thing. I want to go home. They've said, I understand, and whatever we've got to do, let's do.
One final question, if I may. How long do you think is a reasonable amount of time for a family to have to wait before they can return home, like with the baby that they have? Like, how long do you think is a reasonable period of time?
I give them a 2 to 3 weeks. That's the period that I give them.
Isn't it true that people have had to wait much longer than that because the goalposts have continued to change?
I have never experienced that.
Okay, thank
So
you.
I can't say from my experience.
Senator Mallow and then Senator Burns, then we need to move on.
Thank you, Madam Chair. Do you have excessive lawsuits or litigation that's driving the cost of your insurance up? So they just keep going up on the price, though?
I do.
Interesting.
Never been sued. Praise God. Now I feel like I need to knock on wood.
Thank you for your input. Thank you for your testimony. You're a child placement agency, so you're licensed in Georgia, right? And you're probably licensed in other states. I want to go to this independent adoption route. That concerns me, that this is a backdoor adoption approach. Can you enlighten the committee on that for a bit, and then perhaps suggest ways that we could more effectively manage that challenge?
So there is agency adoptions and there is private attorney adoptions. What I saw and what I was hired by these agents, out-of-state agencies, to do was—
Were they agencies or attorneys?
They were agencies outside of the state of Georgia. So they were licensed in other states.
They were licensed in other states,
But not
they
in
were-
Georgia.
But not in Georgia.
And they were working with a Georgia expectant mom. And they placed, then the family usually had nothing to do with Georgia at all. So it was from another state. So because that agency was not a licensed agency in Georgia, and the way that 1984 code says is the surrenders in that case are signed to the adoption agency. So the mother is surrendering her parental rights to the adoption agency.
The out-of-state adoption.
Well, no, hold on.
Okay.
So, and then the adoption agency places with the family that she chooses. But in an attorney adoption, what happens is the surrenders are signed directly to the adoptive parents. No agency is listed on there. So when I say backdoor way, what I was instructed to do and what I did, and I feel was not the right thing to do, was I had mom sign not to the out-of-state agency that wasn't licensed here because nobody needed to know they were involved, but it was signed directly to the adoptive parents. And ICPC never asked, so I didn't tell. And they never knew that the agency from Utah or from Washington was involved in this.
But you had to have an ICPC, is that right?
I did, but back then ICPC didn't really ask for any of that information about how everybody came together. One of the big things that they are asking for now is how were the families matched? You know, who were all the entities involved? Who received money in this? Because they're trying to kind of bring that to light and to, you know, close that back door.
So if trafficking occurs, then this perhaps would be the technique that would be
Absolutely. Absolutely. And in case in point, we had a mom who placed through Abiding Love. She went to the hospital, was given a list of adoption agencies. She chose to call us. We worked with her, helped her with birth mother expenses legally. And then after the law, we couldn't do it anymore. She called me in 2 months after that, and she said, "I'm pregnant again." And I said, "Okay." And she said, and I said, "I'm going to ask a hard question. Did you purposefully do that?" She said, "Oh yeah, because y'all paid for my housing and my hotel, and she was on the streets before." And so I said, "Well, I'm sorry. I ethically don't feel like I can work with you because you purposefully did this." And so I got a phone call 8 months later. And she said, "Hey, I just wanted to let you know I met with an attorney, and I have some questions because all of the paperwork they gave me was extremely different than what we went through with Abiding Love. And I didn't feel like it was legit. And so I asked her questions. And so the agency was out of state. They had wired her money. They had sent her gift cards. The code says that any birth mother expenses, if it's a private adoption, are supposed to go through the attorney's trust account. None of that happened. And I even talked to the attorney that was involved and confronted him because he had been one of my mentors. And he said, "Well, you're just sorry that she didn't go with you." And I said, "No, that is not the case. This is what we're talking about. And unfortunately, this is part of what's happening. And it's not fair to other birth mothers. It's not fair to the adoptees, and it's not fair truly to adoptive parents."
Thank you.
Thank you very much. Next, we have Ashley Mitchell talking about the birth mother experience. And we've got then briefly, Jackie Jackson's going to talk a little bit about a possible bill that we discussed last year in our committee about unregulated child custody transfers. And then we have 7 people up left to testify. So just so you can plan. A lot of interest in this topic, as you can see. So thanks for hanging in there.
Thank you
Thanks for
so
being
much
here.
for having me. My name is Ashley Mitchell, and I'm a birth mother. I placed my son for adoption 19 years ago. I flew in from Salt Lake City, Utah to speak with you today about this topic. That's how important this is here in Georgia, okay? I know I'm an outsider, and a lot of the points that I would bring up today have already been talked about, and so I will try and keep this as brief as possible so the Georgia people can speak on this. But as a birth mom, I think it's very important that you hear from somebody on this side. And in a state that has been greatly affected by rubber stamping of ICPC. I've been working as a national advocate and public supporter of birth mother rights for over 15 years. And my co-founder and I run a grassroots movement to change how Utah adoption is done through Utah Adoption Rights. I had 3 points that I wanted you to consider. The dismissive attitude of the professionals about ICPC is problematic. In November of 2024, the Georgia State Bar gathered and did their adoption CLE for 6 hours to discuss and brought attention and concerns of the overstepping of ICPC, claiming that it is not a necessary legal checkbox, that it can act inappropriately, and not to mention really inconvenient. I encourage you to watch and listen if you haven't. It is very telling. The request for more paperwork, affidavits, money tracking, explanation of how the birth mother and adoptive family was connected, proof that money was dispersed according to law, etc., are not inconvenient. You asked about moving that goalpost and that frustration. Adoption continues to evolve. The internet changed adoption. Consultants changed adoption. It is continuing to evolve. And so this paperwork and these goalposts should move and should evolve with it. These are protective measures that should already be policies in practice. These steps to help prevent the mothers from being taken advantage of coercive activity to take place, and to stop illegal entities from working within the state of Georgia. It is not just the fault of a few bad actors if illegal facilitators and practices of adoption are finalized. It is the fault of everyone that had a touch point in these cases and these practices in an adoption plan. To quote the panel members, during the 2024 adoption CEL, they, ICPC, have most recently attached onto the narrative that this adoption is illegal. There is a breakdown in the system. It is due to this dialogue occurring for whatever reason by ICPC that they have alleged that the mothers are being trafficked. They keep talking about trafficking, trafficking and illegal things. I am sure that in the state of Georgia and other states that this exists. You're looking in the wrong place, end quotes. Which brings me to my second point. I understand that these are sensitive topics and there is a defensiveness when there are sweeping general statements that they don't want to be lumped into. However, they need to be addressed. The level of corruption coming from the unlicensed agencies and unregulated facilitators doing business in Georgia is currently causing harm and drawing attention on a global scale. If ICPC is involved, we know that adoptions are happening across state line, and the line is open two ways, in Georgia and outside of Georgia. Let's look at Utah, which is why I'm here. The unlicensed facilitators and consultants doing business in Georgia almost exclusively work with agencies in Utah. By dismissing the added attention and protection of ICPC, Georgia plays a role in allowing behavior that has caused horrific harm to all members of the adoption constellation, dismisses their powerful testimonies, and ignores extensive investigations and reporting. From money and healthcare frauds, transporting women for the sole purpose of adoption for her unborn baby by removing her from her local social services, licenses of the adoption professionals suspended or revoked, all the way to the imprisonment of attorneys for their actions. I have with me situations, descriptions that a Georgia prospective adopted parent received from our Georgia consultant for a Georgia expectant mothers that were flown to Utah to give birth, sign adoption paperwork, and then were transported back. These Georgia mothers who should have had the opportunity to use Georgia law, which has a 4-day revocation period instead of a 24-hour period that is irrevocable in the state of Utah. They took them away from enforceable post-adoption contract agreements as provided in OCGA 19827 to protect the birth mothers from being promised an open adoption and then being cut out of their child's life. Local resources of their own neighborhood, such as pregnancy centers that could have provided services and connections to help them parent rather than to have them make an adoption plan. Instead, these moms were flown to Utah, put up in compound apartments until they gave birth, signed paperwork, and then were brought back home. What Georgia ICPC is doing is to help ensure that this type of trafficking is not taking place. What Georgia ICPC is doing is ensuring that Georgia does not turn into a state like Utah. Georgia has a chance to continue to ensure that they do not allow those lines to be crossed. You have a chance in a state that has a heartbeat bill that encourages family building through adoption to keep it safe and lawful. As it stands today will be very telling. ICPC is the first line of defense. By the time these adoptions come to finalization, the harm has been done, and now we're looking at potentially adding more problems. I won't get into the ICPC versus the court. The people here in Georgia can better talk on that. Georgia has taken proper steps to ensure that there are knowledgeable sets of eyes on all that is evolved in the moment that is happening, days after placement, not months later. ICPC isn't trying to make this process more tedious or expensive or frustrating for the involved parties with privilege. They are trying to ensure that everything about a life-changing adoption plan is done with the utmost respect, care, and legal practices that adoptees, birth parents, and in fact, adoptive parents deserve. It saddens me in talking to adoptive parents that they didn't even know what the adoption facilitator, entity, consultant, or even attorney was doing was even illegal. Adoptive parents have trusted the adoption professionals to ethically and legally guide them through the adoption process. Sadly, because such large amounts of money are at stake, these trusted professionals have found unethical and illegal ways to traffic women and babies. And yes, I will continue to use the word traffic. That is not a narrative that ICPC has latched onto. It's a word that I'm using because it's a word that is what is happening. I am privileged enough to look back at placing my son, look at the people that were involved, look at all the touch points and know that even with all the struggles, heartbreak, grief, and trauma work that my son and I worked through, that we know that with the information that we had and the people around us, that we made the best decision possible. If you take away the extra pressure that ICPC can put on finalizations of adoption, can you say without a doubt that any birth parent or adoptive parent will be able to stand and say the same thing 20 years later? I beg you to consider us, the birth mothers. We deserve safe, empowered, and informed decisions about us and our children. Adoption is for life, and we should act accordingly. Thank you.
Okay. Question?
No, you're fine. No, it's not for you. Madam Chair.
Yeah.
I just want to make a statement here. If what is being said is true, that ICPC is the safety net, if you will, for lack of a better reason, then it gives me grave concern for adoptions that happen within Georgia that do not require an ICPC. And so I want to name that out loud and flag that for us. Like, if ICPC is the safeguard, I'm saying that with a big if, then we have to look at our internal and interstate, because there is no ICPC process. I might argue that those extensive home studies are also part of the safety net, and that's also happening. But
Yes,
I
ma'am.
just want to flag that for everybody.
Thank you.
Thank you. Okay, Jackie, we've got a handout from Jackie Jackson about the Uniform Unregulated Child Custody Transfer Act. So if you could cover it in 5 minutes, that'd be great, because we've got a lot of people who still want to speak.
Well, I understand, and thank you so much, Madam Chairwoman and committee. I'm honored to be here. My name is Jackie Jackson, and I lead Atlanta-based Ignite Hope Champions for Children. We are advocates for children, and in my personal lived experience and my professional academic experience, I look at this space very holistically. I am a former foster child. I am an intercountry adoptee, and I'm also an adoptive mother twice over. My oldest daughter came through domestic infant adoption, and our son came through a foster situation in a different state. So what I would love to share with you about is something that I was tapped about 2019 to speak into, called the Unregulated or Uniform Unregulated Child Custody Transfer Act. This is an act that several of us in a working group over a couple of years spoke into, looking into, and we've heard the word over and over again, the complications that come with child welfare and custody, and the word trafficking. And I think sometimes when we hear that, so just so you know where I'm speaking from, we sometimes consider the word as sex trafficking, but I believe child trafficking is more where we are talking about. Not that the other cannot happen, but it is trafficking in a very broad sense of the word. And one of the things that has come about after 10 years of working professionally as a child welfare advocate, and then working alongside others across the nation with the ULC, is how do we plug those gaps? How do we put protective measures in place, especially when a lot of adoptions are coming intercountry and being overseen a lot by USCIS or State Department? How do we protect those kids moving in foster care across state lines and domestic infant? And from so many of those who have already spoken to you ahead of time, each one is very specific in how they oversee, how it works. But one thing that we do know is vulnerable children are vulnerable. And those of us that are just caused to speak up for them, caused to make legislation, policy, rules, and regs to protect them, we do best when we are working together and when we are hearing each other. And so I very much appreciate this opportunity to raise my voice on behalf of not only adoptive parents, but a part of the adopted child, which was my own personal experience as well. When I began working on this, we spent 2 years really dialing down on a number of different articles. What this Uniform Act gives is a framework for states to prohibit unregulated child custody transfers. This is a transfer, and the wording is included in the act, that is intended to sever parental ties. It would be a full TPR. This is not at all meant to penalize a biological parent who is military non-deployment or a family who is sick. This is very specifically for a family who, for whatever reason, has decided they can no longer parent the child. And we've been hearing a little bit about there are bad actors and there are backdoor channels of moving children. What I want to make sure is that Georgia is at the forefront of protecting children. And although oversight and regulations can be cumbersome and they can be extensive, I myself spent about 3 to 4 weeks in another state waiting for permission to bring our son home while my husband and daughter flew back to Georgia because we were attempting to manage this and comply with all of the different state regulations. When you have an unregulated child custody transfer, I actually wrote during some other testimony, the difference as I see it is unregulated child custody transfers, you could almost say is giving up a child, which is a term that I don't ever want to use as an adoptive mother or as an adoptee. Whereas making an adoption plan includes regulation, includes oversight, and includes policy that is protective. When we are looking at a situation where a parent is choosing to place in a different home, it's sometimes titled rehoming, which is another term I don't love, but it is something that if you do a search on it will come up. Reuters in 2013 did an expose on the child exchange. That's when you could easily, even in 2019 and 2020, you could go on Craigslist and put in Caucasian, blue-eyed, 6-year-old male and likely come up with some kind of hit. We did that as an exercise when we began working in the working group, which included representatives from ICPC, state placing agencies, adoption agencies, and others like myself who are in child welfare advocacy. What we've seen is a lot of this has turned to more of the dark web situation, but it still is including actual people and actual actors. There have been instances of children being transferred in Walmart parking lots with no oversight, with no medical history, with no social history. And when you have a child who is already vulnerable, who has already lost the safeguards of a protective family, where they are, and this could be an adopted child, it could very likely be a child in foster care or who is CPS identified or is still in the biological home. If you have a home that for whatever reason is facing issues that say they can no longer parent and they are at their wits' end, what happens is they might go on a chat room. They might go, even though we say you can't advertise it, there are still availability of transferring. And what we want to do with this particular act is give our oversight, our DHS, Child Protective Services, give within the state teeth to say that if you're doing this, trying to traffic children, if it's for profit, if it's for sex, for whatever reason it is, that Georgia is going to say we are going to have the ability to not only intervene, but we're going to give law enforcement authority the power to investigate and take legal action to enforce the article. And that's directly from the ULC. As we were looking to champion this, there are currently 8 states, 4 that have enacted, 4 that are considering. I would love Georgia to be the 9th. I brought this to you last year, but I believe listening to the testimony that we've heard here today, it is different. It's absolutely different if it's a domestic infant child placement or if it's a child out of foster care. But every child deserves to be championed. Every child deserves to have safe and stable home, and allowing us to put something like this into place, which can be, it is a flexible framework, so it can work within Georgia's laws as a committee such as yours sees fit. We would be able to address certain child custody transfers that may present dangers of various kinds to children. And in our work, we work preborn to permanency. So sometimes it's abortion vulnerable young moms. Very often the last couple of years, it's been women coming out of domestic violence or human trafficking, sex trafficking themselves. If we are able to put these kind of protections in place, we will be able to be at the forefront across the nation because Child Welfare Gateway, which is I think childwelfare.gov, has already looked into in the last 5 years that there really is a pipeline of vulnerable children into trafficking. It's very documented. I think 70% was the stat I saw most recently, that if you were in foster care, you were 70% more likely to be trafficked. I mean, I sit before you as a child who was in foster care. My son was fostered. These are things that are happening. It is, and I agree that it is not typical that a family who would put themselves through a home study, who would go through all the things, is trying to do it. I have been that person where my finances, my marital relationship, my stance in the community has been overseen and looked at and debated, and it took an act of God and Congress to make me a mom. But I also believe that when we don't have strong policy in place, that transfers in Walmart parking lots, not putting restrictions on the length of time that a parent might need to have a different guardian appointed, that we are really not doing what is in the best interest of children across the board. So I'll very quickly address why, and this is a sheet that I have shared with you, and I'm happy to share any of the other information, but I wanted to steward your time well. The act addresses certain child custody transfers. Of course, we spoke about it doesn't include military, it doesn't include sickness. It's for that transfer that is intended to sever ties with the child. This act is consistent with the recommendations from the U.S. Working Group, composed of representatives from several federal agencies, state child welfare organizations, the National Association of Attorneys General. This act protects children by prohibiting a parent transferring custody of a child to someone beyond a family member. So in Georgia, we do have fictive kin, we do have blood relations. This would be at a point where the parenting parent, be that a guardian, be that an adoptive mother, be that a biological family, says they no longer can handle it and they are looking for any way plausible to, and I have seen this in our own organization, where one child might be, because of trauma and escalated behaviors, may actually be dangerous to other children in the home, and they're concerned about having all the children taken into foster care. There are no real ways to move children into a safe place. And what I propose is that we make sure that every movement of children, just like we have ICPC going between states, that if we're going between Cherokee and DeKalb, that there is something that where a medical history, where a social history, where a judge or a guardian ad litem is overseeing and saying this is good. When it's done without oversight, it is dangerous. And I know that we all want this to be a place that is protective for babies, for children, and for families in Georgia. Thank you.
Thank you very much. I don't think we're going to have time for questions because we've got still a bunch of people who want to speak. So thank you for your testimony.
Thank you very much.
Okay, people who signed up to testify on the sheet, James Outman is first. And if you guys have, if there are things that have already been said that you think you can skip over, then that'd be great. Thank you.
Madam Chairman. I'm going to skip over much of what's been said. I'm an adoption attorney, an adoptive parent, and for 30 years, I chaired the adoption ICLE seminars and would contact ICLE and ask for their checklists. And many, many years, they didn't change, but I published them every year. And I had the ICPC Compact people come and speak or offered them to speak. The changes that we've occurred have been out of character, I just want to say. Again, the purpose of the ICPC is uniformity. We're dealing with an old statute. It doesn't contemplate HIPAA. It doesn't contemplate didn't contemplate the internet. It was written before email. I mean, we're talking about an archaic statute. What we're talking about here is the abuses of Georgia ICPC in its implementation, which are holding things up. So I hope we can't solve all these problems, but I want to emphasize some of the problems. Question was asked about agency fees. In my experience, RCCL, unless they've changed things, doesn't regulate the fee. They want to be sure it's clearly explained to an applicant. So if I want to charge $100,000 for my agency, I'm free to do that. It just has to be clear that when you sign up, that's what the fee is, and it's clear to you, it's not a surprise. Oh, we got a child for you, but there's an extra $50,000 placement fee that we forgot to tell you about. That's the issue on licensing. I want to share with you a case that our firm was involved in last year, which started with a couple from New England who were home studied in their home state, got on the internet, were looking around for adoption resources, contacted a licensed agency in Ohio who said, well, we can help you find birth mothers, put them in touch with a birth mother in Georgia who had listed on the internet. And this is where the problems come from, or the snakes out of the basket from the internet. Contacted the birth mother in Georgia. All they received was a phone number and name, and said that she had an unwanted pregnancy. She already had a child that was in de facto custody. She didn't want this child to go into foster care. She wanted to place the child privately. I contacted the mother, engaged a Georgia licensed agency, came to Georgia for the birth, was there for the birth. The Georgia agency filed the ICPC package. 2 weeks later, on a Friday, the agency had contacted the county DFACS, went into juvenile court and got a pickup order for the child. Well, one of the questions ICPC had asked is, where is the child? Sherry Ann Hicks told you that they asked that question. They got a pickup order for the child with no notice to the couple, no notice to the agency, a licensed agency. The child was surrendered to a Georgia agency. 6 o'clock that night, the police were at the door, picked up the child. What had they done wrong? The ICPC letter said, we think it's likely that an unlicensed agency had been involved. Unlikely. And cited 49.512, which is the section that has been reported on. They took the child. The agency said, oh my God, we're going to get our license, and our license is at risk. They disavowed, they refunded the fee to the clients, surrendered the child back to the mother, washed their hands of it. 49.512.1 says the violation of 49.512 is to file a civil penalty against the agency. That was referred to. They didn't do that. They took the child. They busted up the adoption. I liken it to you and I are driving in a taxi cab. The taxi cab driver's in a hurry. The state patrol pulls him over. We get arrested. The taxi driver didn't get the ticket. They took the child. That happened. That is weaponization of ICPC. It's not in the ICPC purpose is to see that the child will be afforded the same opportunities to be adopted interstate as they would intrastate. That's in the ICPC documents. That wasn't done there. That was an abuse of ICPC. They used the private information. We've talked about medical records, this, that, next thing. The information was shared and went to county DFACS, and they alleged that the child was placed in violation of Georgia law. No judge made that decision. The juvenile judge took the message, swallowed the Kool-Aid, and gave the order. The exclusive jurisdiction of adoption lies with our superior courts, not with the juvenile courts. Juvenile courts don't understand adoption. Many superior courts don't understand adoption. But for heaven's sakes, that was all initiated by ICPC. And that's the kind of wrong that I don't know that this committee or the legislature can, that's administrative, because that starts with the governor and comes on down. But that's an evil. Now, I was so tickled to hear Regina testify and that whole group about the RCCL efforts. I was counsel to the Georgia Association of Licensed Adoption Agencies, 2014 to 2017. We wrote the commissioner, we went to the governor, we went to the attorney general, we met with the inspector general, and they would not police the adoption advertising that's occurring on the internet and the yellow pages we gave them voluminous documents and they'd say, well, we can't tell that they're offering adoption services. I said, why don't you ask them? Oh, we can't do that. That's the evil. We've got these out-of-state entities, and some of them aren't licensed anywhere. They are a virtual agency. You could look at you could have a $1 million website and look like they're in the Taj Mahal. They're sitting in somebody's back room, but they're churning money and whatever. They're poaching Georgia parents' children to other jurisdictions without RCCL and the Inspector General policing that. We changed the law that said you had to advertise in Georgia, you had to list the Georgia license number. That's easy to police on the advertising entities where these ads don't have licensing numbers. Pull the ads off the line. But the effort needs to come from the department to police those things. Yes, we have problems. I'm proud to say that when we wrote the Adoption Act in 1990, we put in, well, in fact, it was in the 77 Act, I think, we put in the first financial accounting that was required in adoptions. And there has to be sworn to, complete affidavits by both the petitioning parents and the attorneys for financial disclosure with the idea of looking toward the violation of an inducement. Those things are there. There's been no prosecution under that. We've added in the 2018 statute that you can now seek to recover damages when somebody is fraudulently misrepresenting that they'll place their child, because we have people come in and say, well, I'll place my child with you, Senator Kirkpatrick. And then Senator Hatchett, I'm also going to talk to you and I want money from both of you. And I'm not even pregnant. And that happens. But when that happens now, it can be public, it can be prosecuted. And there's a civil remedy also. So we've worked to attack some of these evils, but then we have the ICPC office changing their checklists repeatedly with no notice to you. And I think that there's a basic due process that if I have a rule that I want Senator Payne to obey, I need to tell him about that before I say, oh, you're in violation. I changed it last Friday, but you didn't know about it, but I told you you're in violation. That's what's happening. So, excuse me, sir. Anyway, I appreciate the committee's looking into this. I'll yield to the other people and I'll certainly yield to any questions.
Thank you very much. I think people have run out of energy for questions up here. Josie Redwine,
She already testified.
she left.
Yes.
Okay, Julie Wasatski,
Yes, I will be very brief.
you're used to this room. Julie was on our foster care and adoption study committee a couple years ago.
Yes, it's good to see everybody again. My name is Julie Wasatski. I've been an attorney for next year will be 30 years. And I've been focusing on adoption law for the past 15 years. And I just want to say, as I'm the immediate past president of the Georgia Council of Adoption Lawyers, and we as a group are here because we want to comply with the law. We just need to know what it is. As Mr. Outman said, traffickers are probably not filing ICPC packets. I just want to throw that out there. I think that they are probably going through other means. They are not filing packets to be investigated by the government.
Wait, could you say that again?
I said traffickers are probably not filing ICPC packets.
Okay.
And you have in your packets the how the different states across the country are processing ICPC, and you can see that we're way out of line with that. Georgia is very slow, I think that this discussion has been great, and I'm so grateful for you allowing us to come and to air all our grievances. There are a lot of different situations with private adoptions and with relative adoptions. And as you know, as we live in the United States, we travel from state to state all the time. I mean, I myself have probably been to California and North Carolina to see my grandkids a lot in the last year. it's very difficult to imagine that a birth parent may not want to choose a family in a different state, or that a Georgia family may not have possibly a distant relative even that they want to adopt in a different state. So it's not really, it's kind of disingenuous to say that we should only adopt in Georgia, and Georgia mothers should only have to place their children with Georgia families, because that is their choice. And we do, as Mr. Outman pointed out, the snake is out of the basket, I think he said, with the internet. So it's difficult. But that's all I wanted to say. I'm open for any questions if anybody had any. I know you guys are tired and hungry.
I do have a quick question. Are you aware of any findings from Georgia ICPC of human trafficking or sex trafficking or anything like that?
I'm not aware that there has been a finding of that.
Got it.
Thank you very much.
Thank you.
Okay, Reagan and Kevin Pritchett.
Thank you.
Thank you.
I know we're all hungry and tired, so we're going to be brief. We are adopted parents in the state of Georgia. We, after a very devastating medically necessary, hysterectomy, we could not have our own children. We could not have biological children, but we always knew we wanted to adopt. We went through a Christian-based adoption consultant situation in the state of Georgia, who then connected us. We went the multi-agency approach, as it's termed in adoption, and went with several agencies out of the state of Florida and Utah. We've very much demonized Utah here today. And we had a very different experience that I just wanted to briefly let you be aware of with the state of Utah. But the reason we did the multi-agency approach was because, it allows you to cast a wider net. You're able to get your family a tad bit quicker. Whereas if you're going with one agency, that has really steep upfront cost, you can't really afford to do this large, wide net with it. So we went with, like I said, several agencies in Florida and in Utah. We ultimately got connected with our birth mother, who we absolutely adore and we have a relationship with to this day. We have an open adoption, and we were connected with her through this agency in Utah. She personally asked us to be her child's parents. We over Zoom met with her several times. She was in a different state than us, of course. But because of technology, we were able to meet up with her via Zoom several times. She asked us all kinds of questions and she got to know us. And then she asked the all important question on December 5th of 2024 to be our daughter's parents. She then told us afterwards, after we'd accepted that our daughter was born on December 16th. We got up to Ohio, where she was born, and made it. I was actually in the delivery room and I actually cut the cord when our daughter was born. We have a beautiful relationship with the birth mother. And we had a traveler that traveled to Utah to meet us at the location in Ohio where our daughter was born. And she was with both us and the birth mother the entire time. We were in the hospital room next to our birth mother. It was the most beautiful experience. We felt taken care of. And we felt the birth mother was very taken care of. We had dinner with her those 2 nights we were in the hospital. And our adoption agency facilitated this. They were wonderful to deal with. And she was able to ask us all kinds of questions and we were able to get to know her. We're actually going to meet up with her later this year in Savannah. She has family down there. So we have a wonderful relationship, and that all started with our agency in Utah. I will say the negative portion of this, the side of like, this is why we're testifying, was because, like I said, our daughter was born on December 16th. What complicated our case, as we found out later, was that we were a tri-state ICPC. We had to clear Ohio, Utah, and the state of Georgia, which very much complicated things. And because of that, we, as everybody said, we cleared Ohio and Utah, and Georgia it just kept kind of going. So it was into January before we got back home with our daughter. What really stunk about this, of course, is that we missed Christmas with our daughter's new her family. She missed meeting her grandparents and her aunts and uncles and her cousins and all those special things. We were stuck in an Airbnb in Ohio with our newborn daughter, which we were very thankful to have. But we essentially felt that we were, with Georgia. So the process, like I said, we cleared Utah, we cleared Ohio, and our agency and our contacts back home, including our state senator's office, Senator Gooch, was involved in this process as well the entire time. We were keeping him up to date on this process and him trying to bring us home. But what made this so complicated again was that tri-state process, but also that Georgia had added things to this checklist that everybody keeps talking about. And one of those things was certified medical discharge copies from the healthcare system where our daughter was born. They wanted hers, but not only hers, also the birth mother's. That's great. And again, I understand needing these safeguards in place. We don't want children being trafficked. That's never the thought process there. But the health system in which we adopted our child, where she was born, had never even heard of a certified discharge. So they're scrambling, our agency's trying to figure this out because Georgia won't even give us a provisional to come home, because our hospital won't even give us, this certified discharge of the mother that Georgia was asking for. So I think just to sum this all up, clear this all up with where we stand, is again, just this uniformity. ICPC was created for a reason, and it's a very important document, but also the fact that why do we even have it if we're not going to trust the other, 49 states that have also signed it, that are also supposed to, why does Georgia have to be the one that is making this so much more difficult? We need to work on it at a federal level, maybe, again, because this idea of uniformity, but making it harder to adopt in the state of Georgia is not going to fix anything, absolutely nothing. You're going to find a situation where you're probably going to have more children ending up in the public side and ending up in DFACS if you make it harder. And we know what kind of a mess that ends up being for a child. So I'm very passionate about this, and we think the entities that we dealt with, we dealt with some wonderful people. But again, I've heard of a lot of this demonizing the process and adoptive parents, and especially again Utah. And yeah, there's a lot that can be fixed, but there's a reason we have ICPC, and I think Georgia just needs to be one of the components in it. Do you have anything to add?
Just to save time, thank you for allowing us
Ditto.
to see.
Yes. So
Thank you all so much
Yes.
for being here. Emery Lott.
Hello, everyone. Thank you for your time today, and thank you for your patience with all of us. I understand you don't like being held hostage here by all of us. I'll try and make my comments short. I am a foster parent in the state of Georgia. I've adopted through foster care. I've also done, I'm also a private adoption parent. And then since that time, I've worked professionally in adoption, helping families go through the adoption process. And I foolishly decided to go back and do law school in my 40s. And so I'm now an adoption attorney. Well, I don't know if it's congratulations or condolences, but thank you very much. You guys have heard the gamut of information today. I would just like to throw my weight behind the idea that ICPC is an important step in the process, but one step, and it's not the first step. We have licensed agencies, we have licensed placing agencies, licensed home study providers. We have federal and state and local law enforcement agencies that do checks on everyone in this process. We have medical checks on everyone going through the adoption process that submits an ICPC packet. We also have financial records on them. We also have all of that information that goes into these families. And for one step in the process to delay, and as I said, we're doing with y'all, hold families hostage out of state, where they can't travel home, where ICPC continues to have supervisory roles in that adoption placement. And we have all of the other entities there. It's honestly an abuse of the law. It's outside of what the compact calls for. And it's a horrible burden on adoptive families, on the child trying to find a stable placement. And honestly, it makes the state of Georgia look poor in the eyes of every other state in the country and in the eyes of our own citizens. Thank you for your time today. If you have any other questions, I'd be happy to listen to them, or we can all go.
Thank you very much. Okay, Hillary Young. And one more. We're almost done.
I thought I was going to say good morning, but good afternoon. And I have to pick up my son in about 20 minutes, so I'm going to be really fast. I'm Hillary Young. I'm a lifetime Georgian. I'm an adoptive mom of two. I'm an Atlanta resident. So this is my home forever. My husband and I adopted our children in 2019 and in September of 2023. They were not biological siblings, two very different adoptions, two very different processes. We are also always talking about whether or not we'll adopt a third time. So the length of ICPC, how it affects our children, our son being in kindergarten this coming year, really resonates with us and means a lot to me. So this whole morning's been so interesting and really important for me. ICPC does not feel like an attack on adopted parents to me. It feels like another way to protect the children that we have been so tenderly and carefully chosen to raise. That is my number one job as a parent. I tell my son that when he tries to unbuckle his booster seat in the car. Mommy's first job is to keep you safe. And that starts from the moment a woman chooses to potentially place her child with me. So to me, these extra safeguards put in place with ICPC, it being a little more difficult, wanting an extra medical record, wanting proof that we are who we say we are. Why would I not want to give the government that? Why would I not want to give the adoption agency that information? I'm more convinced than ever of the importance of careful, ethical, and meticulous overviews of adoption documents, of adoptive parents, and especially of adoption professionals. I've seen the good, the bad, and the ugly, and I am just such a proponent of ethical adoption. As far as waiting for a few more days, spending a little bit more money on legal fees, for the confidence that my child's adoption, both of my children's adoptions, any potential future children's adoptions, are done completely by the book and above board, I will do anything for that. I need to sleep at night. And these precious tiny humans that my children's birth mothers handed into my arms when they were 2 and 3 days old, they're only these little babies who don't talk back, who don't have questions, who aren't wondering how they came to be in this world. They're only those little humans for a short time. I am always responsible for what was done in their lives. I'm responsible for how their birth mother was treated, how I allowed for her to be treated. I'm responsible for how they were placed in my home. I'm responsible for making sure that everything was done correctly, that she received support, that we received support, that the money that was spent and paid went to where it was supposed to go, that everything was done. I'm the moral standard for my child, and I need to be able to be held accountable to it. And I need to feel good about what I'm going to tell my children about their life and how they came to be. So in my mind, ICPC does not just help to protect adopted children. It feels like an extra step of protection over vulnerable population of birth mothers and birth fathers who are so often missing in this conversation. And frankly, it's the best thing for adoptive parents. Again, as my responsibility is to ensure that their adoptions were done ethically, legally, with conscientiousness and the care of all involved parties. I don't see a world in why we would want less control and less checks and balances to make sure that our children are safe and that they're placed in our homes for the right reasons. So all that to say, I really appreciate your time. And as adoptive mom, I'm in full support of a meticulous ICPC process and in using people who will walk beside you and really make sure that everything is streamlined. Thank you for your time. Thank you for I appreciate you.
Thank you. Do you have one question over here? Senator Rosalynn
I
Parks.
just have a comment because I understand that the delays are not just a couple of days. There was a baby that was put into 5 different foster homes until they were a year old. So I think that there are some things that need to be fixed and nothing was found. So I think that's just egregious.
I would agree with that.
Thank you very much. And last but not least, Elizabeth Edmonds.
Thank you, Senator. Thank you for your time today. I know everybody is ready to go. I am too. I'm hungry also. I know some of you, we've worked together down here a good bit. Senator Kirkpatrick, I really appreciate everything that you did to help pass Betsy's law. Also Chuck, Senator Payne, I appreciate you, and Senator Jackson as well. That was a bipartisan effort to help pregnant and new moms here in Georgia. I really appreciate that. I placed my child for adoption when I was 15 here in Georgia with a Georgia family through a Georgia licensed agency. I was not an emancipated minor. I did not have an attorney with me. I was alone in the hospital. My child's adoptive mother was there with me, and I'm so thankful for that. All I wanted to say to the committee is we've heard from the attorneys that are involved, agencies that are involved, adoptive parents. We've heard from another birth mother, but as a birth mother who's placed here in Georgia, when we're discussing these regulations and safeguards and checks and balances, I humbly ask that you keep in mind how grief-filled this decision is. It is not something that a birth mother takes lightly. It is hard. When I was being discharged from the hospital, one of my nurses looked at me and said, "You're going to want to stop on your way home and buy about a 5-pound bag of sugar." And I didn't know why until the next day I woke up and my arms literally ached for my baby. My body grieved for my baby on a cellular level. It is not a decision that a birth mother takes lightly or is doing to skirt responsibility. And I think that birth mothers should have a right to know that the family we've chosen has been vetted, that the laws are being followed, because as we've heard, adoptive families don't often, they have no idea that the agency or attorney they're using may or may not be following the law. And I think that birth parents have a right to know those things. And I think it's incumbent upon our legislature, you ladies and gentlemen, to make sure that they get those rights. Thank you.
Thank you very much. I want to personally thank the members of the committee who have hung in there. This feels like Judiciary Committee a little bit, and very important subject, and very important that everybody's heard and is on the record. The medical records thing coming from healthcare, I can tell you, is a can of worms and complicated, and our medical records law is a little bit of a mess. So we've got work to do on that, but not everything needs legislation. Many of these things are problems that can be fixed administratively with everybody listening to each other. And I think there's been a lot of listening here today. I've found the leadership at DHS to be very open to meeting with people that are impacted. And I think the ask of a seat at the table in terms of discussion about how to resolve some of these things that are important and yet may need some work. I think we've made some progress today on that, and the committee, it was very important that we understood what was going on kind of with all points of view. So I really appreciate everybody hanging in here that long. We're not done with this by any means, but what we tried to accomplish today was to get everybody heard, and I think we did that. So thank you very much. We're adjourned.